Right. Good morning. I am at-large council member Anita Bonds, chairperson of the Committee on Executive Administration and Labor. The time is 9:35 a.m. on Wednesday, February 5th, 2025. We are meeting virtually via Zoom to convene the committee's second public oversight hearing of 2025, which is also streamed and recorded on the committee's YouTube channel named EAL Committee. Today, we will be hearing from the Office of Labor Relations and Collective Bargaining, the Public Employee Relations Board, and the Office of Employee Appeals. The purpose of today's hearing is to receive public and government witness testimony regarding these agencies' performances during fiscal year 24 and fiscal year 25 to date. Additionally, today we will hear from the public regarding wage theft and the First Source program administered by the Department of Employment Services. On Monday, February 10th, beginning at 9:30 a.m., the public will have additional opportunity to testify to any matter regarding the Department of Employment Services. Today, we will get a better understanding of the scope of these agencies' work, the complexity of any matter before them, and their decision-making process. Given the integral role that these agencies play in the district's workforce, economy, and administration of justice, we can expect to touch upon a host of topics such as bargaining strategies, contract implementation and compliance, fair labor practices, and a commitment to justice, internal agency investigations, more workforce opportunities for district residents, personnel and management interactions, protections from wage theft, retention and growth of employees, sexual and workplace harassment, the implementation of management tools, and timely negotiations, dispute resolutions, and grievances decisions. We want to limit delay and ensure that our method are effective and are conducted with integrity. We must be a government that upholds accountability, measures to prevent retaliation while fostering a labor-friendly environment, and that's a primary reason for today's hearing. At this time, I will acknowledge any of my colleagues. All right, well, we're going to solo today at least for a while, until I guess it gets interesting. Just for the record, there are at least 3 oversight sessions in progress this morning. So I want to thank the members of the public who have joined us, and I know a few are bouncing from one hearing to the other, so we'll probably be joined later, and then we'll move immediately to our government witnesses. And thanks to everyone for joining us today. With that, we'll start with our public witnesses, and I believe we have anyone on?
Not on Zoom.
No one on Zoom. All right. So we are going to, Mr. Slade would be our first witness, but he is moving into another hearing, and he'll be in with us later. So I'll ask the public witnesses who are here if they will come to the witness table. I think I see Mr. Samuels who just walked in, and Mr. Pemberton, I see you are here. Thank you also for being here. And Mr. Slade will join us a little later. And then Ms. Patel is another public witness. She's not here. So you all have the floor. Now, we cannot talk for 45 minutes each. So just remember that, and welcome, and we're ready to receive your testimony. We'll start with you, Mr. Pemberton.
Thank you so much, Council Member. I promise I only have 5 minutes here, so I won't
Want to waste the committee's time. Good morning, members of the committee. I provide testimony today as the chairman of the DC Police Union and on behalf of nearly 3,000 members of the union regarding the performance oversight hearing for the DC Office of Employee Appeals. Unfortunately, over the past 2 years, the DC Police Union has experienced significant delays in the adjudication of these cases, in that its members have appealed to OEA and that has had difficulty even scheduling hearings due to OEA's apparent budgetary constraints. By way of background, prior to 2023, union members primarily appealed disciplinary matters to neutral arbitrators who were jointly selected by the union and the Metropolitan Police Department from a large pool of arbitrators provided by the Federal Mediation and Conciliation Service. After an arbitrator was selected, the parties would advance the disciplinary appeal to an arbitration hearing, after which the losing party would pay the arbitrator's fee. On June 8th, 2020, the Council passed the Comprehensive Policing and Justice Reform Amendment Act, which amended DC Code to preclude the union from bargaining with the department over discipline. In response, the department revised its disciplinary system to prohibit union members from appealing disciplinary matters to arbitrators. The direct and immediate result of the passage of the act and the removal of arbitration was that all appeals of discipline filed by union members were required to be filed with OEA. Prior to the passage of the act, the union advised the council that OEA would be unable to handle the volume of disciplinary appeals filed by union members, and now, 2 years later, these warnings have proven to be true. Specifically, over the past 2 years, despite only appealing 2 termination matters to OEA, OEA has yet to issue a decision in one case and took 8 months to issue a decision in the second. In one case, the union member filed his appeal with OEA on August 1st, 2023, and after the passage of more than 14 months, still had not received a briefing schedule from the administrative law judge assigned to the case. Ultimately, after several requests from several requests for the issuance of a briefing schedule went unanswered, the member was forced to file a motion with OEA requesting that the case be reassigned to a new judge to allow the case to proceed to briefing. Such lengthy delays deprive union members of due process and could ultimately result in hundreds of thousands of dollars in additional back pay being awarded to members who are ultimately reinstated with back pay after these lengthy delays caused by OEA. Similarly, several union members have appealed indefinite suspensions without pay to OEA. In these matters, union members desperately need prompt adjudication of their appeals since they've been placed in an indefinite unpaid status. Despite being indefinitely suspended without pay, the department has also precluded these members from working any other employment, thereby putting these members at significant risk of financial ruin. The legitimacy of these suspensions without pay and the department's preclusion of members working outside employment has been repeatedly appealed to OEA, yet to date, none of these members have received a decision or even a hearing from OEA on their appeal. Such unnecessary delays have caused members to be placed under severe financial distress. Several union members have also appealed disciplinary matters in which they have received suspensions greater than 10 days. To date, only one of these cases has been scheduled for an evidentiary hearing, and OEA has not yet issued a decision in any of the cases. For example, on January 6, 2024, a union member filed an appeal of a 25-day suspension with OEA. The evidentiary hearing in this appeal was not held until November 21st, 2024, nearly 1 year later. Incredibly, in attempting to schedule evidentiary hearings with OEA, counsel for the union has learned that by the summer of every fiscal year, OEA exhausts all of its funding and halts scheduling any new hearings until the following fiscal year. As a result, many cases languish for months until the new fiscal year because OEA does not have money in its budget to pay for court reporting services for its hearings. During this time period, it appears that OEA does little to advance its caseload. Over the past 2 years, despite filing a very small number of disciplinary appeals with OEA, DC Police Union members have only received one decision from OEA on the merits of any of these appeals. The failure to receive prompt adjudication of the disciplinary appeals is incredibly discouraging to all district employees and deprives employees of due process. Unfortunately, the rush to remove the ability of DC Police Union members to appeal discipline to arbitrators and the failure of the council to dedicate appropriate funding to OEA has caused the current untenable position. I stand for any questions, and I thank you for your time.
Thank you very much for your testimony. And would you make sure to enter a copy with?
Yes, ma'am. I'll upload the written copy
here.
shortly.
Yes. Thank you very much. Mr. Samuels will take your testimony.
Thank you so much. Good afternoon, Chair Bonds, members of the committee. My name is Alex Samuels, and I work at DC Jobs with Justice, an organization that supports DC workers who've had their wages stolen. For over 20 years, we've educated workers on their rights at work, supported their cases with the Attorney General and the Department of Employment Services, and advocated for policies that make DC a better place to work and live. As you know, we're in a complicated political moment. The federal government has sent mixed signals about what will happen next, and I'm certain the council is having a difficult time strategizing. But the federal government has been united in its hostility to immigrants and immigrant workers. Already, agents of ICE have been sweeping our communities.
Excuse me, Mr. Samuels, could you move your mask?
Yes.
Thank you. Thank you so much.
Already, agents of immigration and customs enforcement have been sweeping our communities, and many of my immigrant neighbors fear for their livelihoods. In such an environment, employers have more freedom to take advantage of their workers. Numerous economists and sociologists have identified that undocumented workers face particularly high rates of wage theft and other violations of workplace rights. Employers know that these workers are less likely to report abuses because they might be flagged by the government as a person who's in the country illegally. The Biden administration was able to mitigate some of this fear under the Deferred Action for Labor Enforcement, or DALE, which gave immigrant workers temporary visas if they reported workplace abuse. DC Jobs with Justice assisted numerous workers through this process in 2024. However, this program has ended under the Trump administration, and in its absence, a culture of silence again pervades our workplaces. As workers hesitate to come forward, it's imperative that the Department of Employment Services step up to proactively investigate employers. DC can no longer operate on a reactive approach that requires workers to bring their cases to DOES and OAG. Such a strategy forces our immigrant community members to choose between suffering in an abusive job or risking deportation and separation from their families, a choice no one should have to make. In this time of heightened fear among immigrant communities, the agency could have a unique role to play in providing relief. DOES itself could take on the burden of uncovering wage theft, proactively auditing businesses in industries known to engage in high violation rates, such as construction, restaurants, and hospitality. Proactive targeted enforcement reduces wage theft across businesses since they understand that this is an issue that the district takes seriously. However, DOES has yet to prioritize labor standards enforcement. Nor in its mission statement, nor in Vision Forward is labor standards enforcement even mentioned, let alone identified as a priority for the agency. The agency's most recent annual report also doesn't mention labor standards enforcement at all, except in a brief description of the purview of the Office of Wage Hour. DOES only reports on enforcement activity when asked directly in performance oversight hearing questions, and their answers tell the story of an agency that has been underperforming similar agencies in other cities for years. The bottom line of my testimony is this: no one should have to decide whether they're willing to risk deportation to report that their employer is stealing the wages they earned through hard work. Last year, the OAG's Swahili Village case settled, and it was revealed that the restaurant had been paying its immigrant workers as little as $5 an hour. In today's political environment, it's unclear whether workers would be as willing to come forward to support such a case, and these unlawful business practices would continue. It's up to you, Chair Bonds, and this committee to ensure that this agency protects the workers of the district. The committee could take an active role in engaging DOES on the following questions: how they plan to pivot their activities to address the increased precariousness of immigrant workers; two, how they will ensure a welcoming environment with effective language access for immigrant workers seeking services; and three, how they will use the full power of their office to ensure immigrant and other workers receive all of their wages and benefits. Thank you for your time, and I look forward to answering any of your questions.
Thank you very much for your testimony, and thanks for removing your mask. A little clearer. Our next witness is Ms. Trupti Patel. I see you're on virtual. We'll take your testimony. Thank you.
Good morning, Chairperson Bonds. Thank you for hosting this hearing so that I can enter my comments into the record. My name is Trupti Patel, she, her pronouns. I am the Chair Emeritus of ANC 2A, and I represent Single Member District 2A03, which is historic Foggy Bottom. But most importantly, I'm DC's longest serving elected official that is a tipped worker. And I want to attach myself to all of my to all the comments made by Alex Samuels. I also have worked with DC Jobs with Justice around wage theft issues, as well as the Restaurant Opportunity Center DC around especially helping our more vulnerable industry workers who have faced wage theft to such degrees that they have literally gone months without their paychecks because due to their documentation status. And the reason why I'm here is to amplify and highlight a policy known as Initiative 82, which talks about raising the floor and to say the sky is not falling and make sure. And what it is this is a policy that allows workers to make it very easy to figure out if their tips along with their wages actually do meet the legal guidelines. And I won't say your staffer's name, but there's a staffer on your team who actually worked on something called wage transparency in its law. And I have had to actually consult other DC agencies around wage transparency issues on behalf of other workers throughout the city who have said that they don't know how to figure out they're getting paid because their employers don't want to tell them how the respective tip pool system works, how the allotment of tips happened. And we're in 2025. The fact that we have people who, if they try to ask questions around their wages, any kind of laws that protect workers, they face immediate retaliation. I have worked in restaurants where, my undocumented colleagues are too scared to go ask their bosses about their pay, and it is easier for them to quit because it is so traumatic for them to go get their money, even though like I, as an organizer, have gone and explained to them that there are protections for them. And right now, the most vulnerable workers in our city don't feel any sort of protection from anyone. And this is a really horrific time to be a worker in this city, especially if your documentation status is in question. And for all the work that all of us advocates on the ground do, it's, it's tough to get people to come forward. And, just as Mr. Samuels said, I think the agencies in DC need to stop being reactive and it needs to be proactive. And it really, really needs to start shaking up all of the industries in this city to say, stop messing with workers, stop messing with their pay, and they're protected. And, I think I'm about to go over my time. I want to be very respectful. So I just want to state that, you know, the agency needs to stay centered and focused on protecting workers. It has, the performance of this agency has been, could use a lot of improvement. And it's the fact that a lot of the time the staff is overworked and underpaid, and there's not enough case managers or examiners around this. And we need to shift that and we need to change that. So I will upload my testimony for your records and happy to answer questions. Thank you.
Thank you. Thank you, all three of you. I appreciate your testimony. Ms. Patel, may I just start with you? And I want to make sure that I have my notes correct. You're saying that there are a fair number of employers that are not informing their staff as to how their salary is computed. Am I correct?
That is correct, Chairperson Bonds.
Okay. All right. And do we have in the restaurants that you worked in, have you noticed if there's any instructions posted at the work site?
I'm glad you asked that question, Chairperson Bonds. Actually, no, they don't. It's actually been pulling teeth. DC law requires that if you are a tipped worker in the employee handbook, the policies to be spelled out exactly how every person that is classified as a tipped worker is to be paid. And that was not the case in my employer's handbook. And if you would like me to submit that for the record, I'm more than happy to do so. I also worked for another previous employer where the handbook specifically stated exactly how our wages would be calculated. A lot of times in this situation, Chairperson Bonds, people don't want to show the records, or they say, well, we don't want to publicize it. And I'm like, there are ways that you can let every employee in an establishment know exactly how their pay was calculated. You don't have to put their name next to like the figure. You can assign PIN numbers to every employee so that when the information is released or should be released on a weekly basis along with your paycheck, you can find it. If Chairperson Bonds, if you were to instruct DOES to actually look into paycheck practices of every single employer, you would find, I'm going to throw out a random number, but I think you would find an 85% non-compliance rate.
All right, thank you. We will have an opportunity, as you know, to talk with DOES a little later in this particular cycle. But it just comes to mind that posting may make a difference. I recall years ago, there was another situation, and we moved to requiring posting of information. And that, of course, would mean posting in several languages, because we recognize that the people of the District of Columbia do speak various languages. It's not just English that is spoken here. So I can work on that. You got a commitment for me to work on that. The other issue that you mentioned, and Mr. Samuels also mentioned, is how do we make or get the agency to understand the importance of being proactive? And we will certainly examine that issue with the agency when they're before us. Now, can you give me some thoughts when you say proactive? Are you thinking that the agency would have inspectors that would examine the records of every restaurant owner at a particular time? Are you thinking this is something that would happen annually, or what are your thoughts about how that might happen?
Chairperson Bonds, are you directing it to me, Ms. Patel?
Yes, you and Mr. Samuels. I'm sorry, Mr. Samuels is sitting here, so I'm looking right at him. I'm sorry, both of you, please.
I'll let Mr. Samuels go ahead and take the first question, take it first, and then I'll respond, Chairperson Bonds.
All right.
Thanks, Ms. Patel.
Thank you.
DOES has inspectors and auditors. This is completely within their purview and within the scope of the law for them to proactively investigate employers. I don't think it's reasonable to expect them to investigate every single restaurant in DC all at the same time. But like they could do random audits. They could also do, there's something, best practices in the industry, such as it is strategic enforcement, which is you go for big name players or larger businesses with the idea that that sort of tells people that you're out on the beat. It tells other people or other restaurant owners that like, this is a thing we take seriously as DOES. We want our workers in the district to get paid. And you should check your records, make sure you're doing the thing. And the other part of strategic enforcement is doing very industry specific work. So in construction, going for people at the top of the supply chain with the understanding that then sort of moves down to other, to like the subcontractors and the subcontractors. That's what's coming to mind right now.
All right, so you're informing that you're thinking all of the various employment industries that we have. You're indicating that there's a need for proactive ism from the agency to take a look at the opportunities for wage theft throughout the city and our commercial corridor. Okay. That's a tall order. I'm just thinking through, yeah, so I see where you're coming from. Ms. Patel, you want to add to that?
Uh, yes, and thank you, Chairperson Bonds, for the question. And like I said, realistically, we can't have people, in an ideal world, it would be great to assign people to literally examine all of like the industries that are referred to as very notorious for wage theft, to have them do this on a weekly basis. You know, monthly, annually, I think is too long of a period, but I think it should be done perhaps in a quarterly basis. I also think any establishment that has had wage theft proven needs to be perhaps on a much stricter under much stricter scrutiny, and should not be someone that's allowed to, like, that should not be audited quarterly, perhaps every like once a month in that case. I also think, and I know the law has been pretty rigid and strict on this for quite a few years, but I think given the nature of the new presidential administration, I think if a worker in an establishment contacts DOES and states that there's suspicion of wage theft happening to a targeted group of workers who happen to be, classified as undocumented and do not feel safe coming forward, I don't think the answer and response from respective agencies they have to be the lead complainant. Sometimes just getting that tip is enough to go ahead and just do a preliminary audit. And a lot of the times when agencies actually do take that approach is like, somebody flagged a concern. We're now going to go ahead and audit you, and we're going to conduct an investigation, and I need you to not interfere as you, the employer. I don't know if that is a reality that can exist, but I think you would, number one, mitigate a lot of these concerns and issues that you are hearing myself and Mr. Samuels echo about our undocumented workforce. And, and I also think that, the fact that there is rigid due diligence coming out of this agency is going to be like the huge wage theft prevention initiative in itself. Everybody always behaves when they know mommy and daddy are watching you, literally. And, I think it's a really sad state in our society where, I will say it for myself that, I have the privilege to be able to come speak to you today, Chairperson Bonds. Our undocumented colleagues cannot risk their health and safety to come tell you this. But let me assure you that these transgressions are happening. And I want you to know Swahili Village is actually in my ANC commission. And in 2020, I was getting reports from workers who were telling me about the rampant wage theft and horrible conditions they were working in. And I tried to flag this with DOES back in 2020. And the reason why I'm going on record about it right now is that a lot of times, a lot of these big cases that the Office of Attorney General wins for workers, in reading the history, you will always see that somebody tried to come forward years ago and was dismissed or ignored. And I think we need to treat every single person that lodges a complaint and says, can you please investigate my employer, or can you investigate this place, I think should be the approach that DOES takes. Thank you.
Thank you. And thank you both for your very clear concerns. And let's see if we can, well, of course, we have the opportunity to hear from more, as we continue this oversight process. And we want to take their concerns also into consideration. I don't want to jump the gun, but it sounds like we probably do need to focus a little more attention on what's really going on in the salary, department. So want to take a look at that. So thank you very much. Mr. Pemberton, you are, best I can recall from your testimony, that it seems that OEA is taking far too long to reach decisions. And it's really creating a situation of pain and harm to our officers that you're representing. We'll ask the office about their time frame and about, their concern. I think you mentioned that they've reported that they don't have the funds to pay for court reporters. And that's one of the areas of claim for the delay. Am I correct?
That's one of the areas, yeah.
Okay.
But overall, what I would say is it does not seem like OEA is equipped to handle the volume. I think one thing that's important is that the police department acts as a paramilitary organization. We have 6,000 pages of orders and directives. Officers are routinely disciplined for what I think we would all objectively refer to as minor infractions. Uniform violations, or, eye rolling and roll call, or, things that I think we would all say are, I'm not defending the behavior here, but that would fall under or minor misconduct. And the problem is as MPD investigates those, we often find that they're issuing penalties that fall outside their own table of penalties that exists. And so that triggers an appeal. The union will then appeal those cases on behalf of the member, given the fact that we don't believe that the penalty is commensurate with the misconduct that's been identified. We used to have a process for this, which was to go to independent arbitrators. And obviously, there's an unlimited volume of independent arbitrators that can be jointly selected by the parties. That right was eliminated when the council prohibited the union from collectively bargaining over the disciplinary system. And the response was that MPD immediately rewrote their disciplinary policy to carve out arbitration and to rewrite the policy and procedure that exists in the disciplinary environment. The easy way to fix this is to restore the right to return to the neutral arbitrators and take this out of OEA's purview and return it to the way that it has been in time memoriam for the past 40 years, and take those cases back to arbitration. And then OEA would not have to worry about expanding their caseload and their budget and their staffing for ALJs. That's a very easy fix.
Okay, so with the arbitrator system, was the arbitrator given the ability to arbitrate any case at any level, whether it was minor or at a higher level of concern?
The prior disciplinary policy stated that any adverse action, so not corrective action, those are the two categories of discipline in MPD, which is corrective action, which is what I think most people would refer to as being written up, and then adverse action, which typically is a suspension or a fine of some kind. So any adverse action that was issued to a member by MPD, that could go to arbitration, which is another issue that I didn't bring up in my testimony, but OEA will only accept the penalties of 10 days suspension or more. We often see the department settling cases when the union gets involved for just short of that to avoid the ability to trigger that appeal to OEA. Which is another issue. But I think the purpose of my testimony here is to suggest that I don't think that OEA is going to be able to handle the volume. And one other thing I should mention is that this new disciplinary system that has been in place since the most recent CBA went into effect, there was a sort of rolling effect. Members whose investigations began prior to that date were under the old system, and then investigations that began after that date, which was November 27th of 22, fell under this new system. So as time has gone on, we've seen fewer and fewer cases under the old system, and now the majority of cases or all, excuse me, all of the cases are now under this new system where everything goes to OEA. So the volume is increasing from our side because that time frame of cases that existed under the old contract, that time has expired. And so I think our concerns here are that without significant budget and staffing increases to OEA, there's going to be a drain on resources for the OEA. And not only is that going to impact my members, but we're, I think, 10% of the public sector workforce here. So there's another 90% of the population that has to use OEA for these same purposes, and it's going to gum up the works for them as well.
All right, are you telling me that this, the change in November 2022 is in the contract, the FOP contract?
It is. So the current contract that we're working under, which went into effect on that date, has eliminated all of the disciplinary articles based on the Comprehensive Policing Justice Reform Act. So once all of those articles were removed from the CBA, the department then had the ability to issue new disciplinary policies without having to bargain with the union, which they did the same day the contract went into effect.
All right, and you're telling us the effect. The effect is that there's a slowdown in reaching decisions in these cases. Minor misconduct. Give us some examples of what minor misconduct is. Is it that your uniform, the tie is not straight, or what is it?
We have examples of, officer has a bad day and he mouths off to his supervisor. He says something insubordinate. Let's say an officer responds to a scene to take a report. He has a poor interaction with the citizen. Maybe there's some exchange between the officer and the citizen that's inappropriate. The citizen complains. There's an investigation, and that results in discipline. Lost property. Officer has, we're issued dozens of different items. We're responsible for maintaining those items. Occasionally, items go lost, right? Officer sets something on the trunk of their vehicle when they're on the scene of a crime. They forget to grab it when they drive away. It's now gone, and they have to answer for that. But these are the situations in which the department will come down. They'll conduct investigation, and then they will issue adverse action in the form of suspension. And when the union steps in to adjudicate those issues, we're now taking all of that to OEA, which I think has been an unexpected burden on the agency.
So in FY24, how many of those types of cases did the union attempt to adjudicate?
I can get that for you. I
Would
don't
you
have it in
please?
front of me, but I can send your staff an email with those numbers. Yes.
Would you please? Thank you. Within 10 days?
I could probably do it before the end of the week. Yes, ma'am.
All right, thank you. That would be very helpful. Now, has the union also been involved in, let's see, trying to read my notes, adverse action?
So yes, adverse action. I mean, any time a member is issued discipline of any kind, they typically go to the union for advice on seeking adjudication of that matter, or at least explanation.
All right.
Adverse action is what the department refers to as department level discipline.
Okay.
And we do handle those matters. Yes, ma'am.
And could I get the numbers for those types also for 24? That would be very helpful.
Yes, ma'am. No problem.
Because I think we have to establish, volume. Okay, workload. All right. What is, or do you have information that would tell us the average or the medium time frame for resolving a minor misconduct issue?
As it is currently under OEA?
Well, yes, I guess we'll take OEA, and then I'm interested if you have data or any indication as to how it's done in other, local jurisdictions. In other words, are we a standout? That's what I'm trying to understand.
I understand. I'll try to
Mhm.
get you that information as
Okay.
well.
And the same as it relates to the adverse actions. That would be very helpful.
Yes, ma'am.
And I believe you indicated that the OEA um, only is interested or is showing that they're interested in situations where the individual is suspended for more than 10 days. Is that correct?
That's right. That is the policy at OEA. They do not consider cases of discipline less than 10 days suspension.
All right, okay. All right, we will examine some of these issues a little later when we have the agency before us. We have our fourth presenter. You all, please, I won't hold you.
Thank you,
Thank you
Councilmember.
very much. Thank you.
Thank you,
Mrs.
Councilmember.
You're quite welcome. Mr. Slade, Vice President of ASME Local 2743. Again, please, for our public witnesses, make sure we get a copy of your testimony. It's very important.
You should have a copy. I
We-
believe I submitted that.
All right, okay.
Thank you so much for allowing me to testify. Good morning, Chairperson Bonds, members of the committee. My name is Arthur Slade, Vice President and Shop Steward of ASME Local 2743. The District of Columbia Public Employee Relations Board, or Board, is an impartial, quasi-judicial, independent agency empowered with the exclusive jurisdiction to resolve labor management disputes between agencies of the District of Government and labor organizations representing employees of various district agencies. The Comprehensive Merit and Personnel Act of 1978, CMPA, was enacted as one of the founding tenets, of the District of Columbia by establishing that collective bargaining was in the best interest of its workforce. In addition, DC Code 161701 states the following: the District of Columbia government finds and declares that an effective collective bargaining process is in the general public interest and will improve the morale of public employees and the quality of service to the public. As a union representative that has petitioned cases before PERB, I would like to ask the committee to consider the appropriation of additional funding to PERB's FY26 budget for additional personnel that may be needed to handle the cases petitioned before PERB. In addition, to ensure that the current PERB personnel are compensated accordingly, as it is my understanding that several FTEs compensation agreements are not collectively bargained to receive cost of living adjustments. PERB has issued two unfair labor practice decisions against DISB for violation of DC Code 161704A4. The first was an initial determination that DISB committed an unfair labor practice. The second was a denial for a motion for reconsideration upholding PERB's initial findings. Moreover, PERB has granted a petition for enforcement of the above referenced PERB decisions. Our members should be afforded the fundamental rights afforded by the CMPA without fear of retaliation and/or reprisal by management. I would like to thank you, Chairperson Bonds, for your leadership in supporting the unions to create collaborative partnerships with management as well as the District of Columbia. Thank you for allowing the submission of my testimony, and I'm available for any questions or concerns at this time.
Thank you very much, Mr. Slade. I don't have your testimony here, so I want to make sure I heard you. Are you speaking about the lack of salary increases? I'll just put it on the record. Salary increases for members of the union, or are you speaking about the office employees at PERB?
Well, I'm speaking in this context for the employees at PERB because I'm trying to make sure that PERB's budget is increased, because given the federal climate, the federal climate and certain things that are going on at the federal level, I believe they may experience an uptick in cases that'll be petitioned before PERB. And they process the cases accordingly, but I want to make sure that it's understood that there may be some type of increase in the caseload at PERB. And, they are pretty diligent in trying to make sure that they handle and respond accordingly. But I just want to make sure that they have the appropriate staff to do so.
All right. And so I'm glad you mentioned that because that's been, of course, one of my biggest concerns today, last week, and probably going forward. And that is, what kind of impact do you see the actions taking place or proposed for the federal workforce that will impact us here in the local workforce?
Well, there have been some rumblings about reclassifications at the federal level, the removal of civil service employees. I believe the administration has issued current buyout clauses that will impact a large portion of the federal sector. I don't know if that will have any trickle-down effect to the District of Columbia government. As you know, Council Member, the funding has been cut at this time. For all funding is ceased. I don't know when that particular funding will be reinstated. And I think that that is something that the district needs to be concerned about because it's my understanding that's going to be about 6.3 billion or a portion of our upcoming FY26 budget that we're relying upon. But through local revenue funds, that's my concern, that we just make sure that we have the adequate staff at PERB to be able to deal with some of these issues that are coming down the pike, and they're coming down rather quickly. And the National Labor Relations Boards is pretty much synonymous to PERB. They're seeing an uptick, so I would imagine that at some point there will be an uptick at PERB on the local level.
All right, well taken. Your union, let's talk about your union and for a minute, what is the workload for PERB based on complaints from your union? Are there any, or
Well, we
has it
have
increased over the years being since, let's say, FY22?
over the past several years, we've seen an uptick in PERB-related petitions for unfair labor practices, specifically dealing with retaliation and or reprisal for dealing with, for participating in protected activities. Some of our members are fearful to come forward in a forum such as this because they are fearful that if they voice their concerns that they have for their working conditions, that they will be retaliated upon. Now, that has been transferred in my role, as well as the president's role, to petition PERB to try to address some of these matters, as well as training purposes, safety protocols, and things of that nature. So specific numbers, I would say, I believe that we've petitioned PERB over the last couple of years, I want to say about 20 cases, but we have 3 agencies. We have ABICA, DISB, as well as DLCP and DOB. Because as you know, DOB and DLCP used to be formerly known as DCRA.
DCP,
DLCP,
okay,
DOB, ABCA, and DISB.
okay.
So our membership is spread along those 4 agencies.
And your membership is, what's your membership?
Count?
Yes, your count, yes.
I think maybe 195 to 200. I'm not sure.
Okay,
I think so. I think it's right around 200, I want to say, but I'm not quite sure. It should be somewhere up in
okay. Okay, so it's 200 and not 20,000.
there. No.
I just want to.
No, we're not.
just wanna-
We're not. We're not.
make
We're not
sure.
MPD. We're not
Okay.
nowhere close to MPD.
All righty, thank you for that. When you mentioned fear by employees, and given that PERB is the process that we have in place, why is there fear?
Well, because that if they have a concern, and this has been across the agencies, that if they have a concern, whether it be dealing with compensation or working conditions, that it usually falls upon deaf ears. And, it ultimately lands, we have to document the behavior of management or any misconduct or unprofessionalism. And specifically what comes to mind at DOB is the management representative who was working 2 jobs and was actively involved in personnel decisions. And she was fined, I believe, $25,000 by the District of Columbia government, but she was actively involved in personnel actions against employees over at DOB. And my question is, how could you have a person that's committing fraud involved in personnel decisions, resulting in a person losing their job that's a District of Columbia resident?
Well, we all would be asking that question once we find out, but usually persons who are violating our government, you don't find out until you find out. It's not like there's some profile that you look for and know that that's the one that we should keep our eye on. So we all understand that. I just received your testimony. Thank you very much. So we have that 100%.
Thank you.
We'll talk to PERB a little bit about whether or not they, what their volume is and how they can perform. I'm sure they too have concerns about the likely increase in complaints. I would imagine at this point, many of our employees have a considerable amount of anxiety. I know that I do when I think that the District of Columbia, while we operate under home rule, we also are still a federal entity. And if you digest that, you begin to be concerned about, members of our workforce, for sure.
Yes, but I support PERB wholeheartedly as an organization because it gives employees, specifically within the district government, a platform to voice their concerns. And although it's quasi-judicial, I mean, it's a proper forum for, establishing some type of constructive dialogue. And they've been responsive to my locals' concern. I can't speak for other locals, but PERB has been very responsive in addressing and attempting to accommodate dates for hearings, mediation, and things of that matter. So they are going out of their way to make sure that my local is addressed. And I think that moving forward, I'm just concerned that with everything going on at the federal level, it's going to trickle down, and they may need some more staff upcoming. And I know about the physical constraints with the District of Columbia government, but I felt compelled to come down here and give some type of testimony.
Thank you. Thank you very much. Now, your local 2743, the classifications that are in that local, what are they? Are they the technical staff?
Professional and scientific.
Professional and scientific.
Professional and scientific series.
So what kind of science do we do?
Well, we look at we look at contractual. I don't know if it's science, but it's trying to interpret contractual information from insurance companies to make sure the district residents are understanding. Sometimes people don't understand that insurance contracts are contracts of adhesion, meaning that once you pay that policy premium, you've agreed to everything within that contract. And of course, there's going to be some exclusionary language in those contracts. And oftentimes, if you're dealing with healthcare issues, you're going to have limitations on if you participate with a particular network or if you go out of network to seek treatment. You also have automobile insurance companies that are charging premium rates, premium rate increases. So it becomes a scientific process if you're trying to determine What's the accident ratio for Ward 8 versus Ward 1? Where the accidents occur are most problematic throughout the city. And this goes not only to automobile insurance, but homeowners insurance as well. So you're establishing premium rates, which is an actuarial science based on the loss history of the claims that are submitted to various insurers within the district.
Mr. Slade, I really appreciate you sharing that. I wasn't sure to what depth you would go, but I think it's very important for the public to know that we have an operation within our government that is required to interpret the meaning of these insurance policies and programs. And in today's world, your team is very, very valuable to the status quo. So thank you very much for your work. And now we know what professional and science type of employees are very valuable. District of Columbia community. And I'm hoping that the ANCs, advisory neighborhood commissions, will invite you and representatives to come and talk with, have an opportunity to speak at their meetings. Because as someone who has, like, for instance, DACL, I have DACL in this committee.
Mm-hmm.
And one of the biggest concerns we get from the senior population is, you know, what are my rights? I don't understand the fine print. I don't know about this. I want to leave this property to my daughter, but I don't want my son to have any of it. So it's really, you know, all of those nuances of daily life that are very important. And it sounds like your team of employees can be very helpful. So we will pass your name and contact along, and maybe you can help the commissioners who constantly have these kinds of questions from their community members.
Yes, I had the opportunity to go up to Hattie Holmes not too long ago and kind of talk about some of the very issues that you're speaking about: estate planning, trying to set up trusts, dealing with not so trustworthy children to handle your affairs.
Yeah.
So that was one of the things that we kind of reviewed in talking about.
Well, thank you very much. And we'll talk to PERB and see where they think they are going into the next few months of our government in FY year 2025. Thank you very much for your testimony.
Thank you so much.
Thank you. With that said, we are prepared to hear from the district's collective bargaining and workplace adjudicatory bodies, and we'll begin with the Office of Labor Relations and Collective Bargaining, followed by the Public Employee Relations Board and the Office of Employee Appeals. So looks like we're being joined at the witness table. Now, I'm sorry, testimony table. All right. And if you will raise your right hand, we'll swear you in. All right. Do you swear and affirm that the testimony that you're giving before us today is correct? All right. Okay. Thank you so much. And Mr. Maxwell, you can begin when you're ready.
Good morning, Chairperson Bonds and members of the Committee on Executive Administration and Labor. My name is E. Lindsay Maxwell II, and I am honored to serve the residents of the District of Columbia as the Director of the Office of Labor Relations and Collective Bargaining, also referred to as OLRCB. Thank you for this opportunity to testify on the performance and activities of OLRCB during fiscal year 24 and the first quarter of fiscal year 25. OLRCB is organized into 3 units: negotiations and contract administration, litigation, and administrative support. The Negotiations and Contract Administration Unit is responsible for negotiating collective bargaining agreements, or CBAs, that control the wages, benefits, and other terms and conditions of employment for unionized employees. The unit also trains management representatives on labor law, policy, and the provisions of each CBA that is applicable to their respective agencies and conducts impact and effects bargaining over subjects that are statutorily deemed management rights. OLRCB's litigation unit is focused on initiating, prosecuting, defending, and monitoring a wide range of litigation activity for agencies under the personnel authority of the mayor. This litigation activity consists primarily of interest and grievance arbitrations, unfair labor practice complaints, enforcement actions, and arbitration review requests before the PERB. The administrative unit is responsible for providing general agency support and conducting research and analysis necessary to support management's position during the negotiations and litigation. It also provides human resources, contracting and procurement, and other related customer and operational services for the agency. In addition, this unit supports the Negotiated Employee Assistance Home Purchase Program, or NEAP, which assists unionized district employees seeking to buy homes within the district with closing costs and down payments. OLRCB partners with the Department of Housing and Community Development and the Greater Washington Urban League to assist with administering the program to eligible unionized district employees. In FY24 and FY25 to date, OLRCB staff includes 20 full-time equivalent positions, or FTEs, and of these positions, 11 are designated for attorneys, 8 for administrative support, and 1 position for the director. Attorneys are directly involved in carrying out the primary mission of the office by providing advice, counsel, and representation to agencies on all matters concerning labor relations. In addition, attorneys actively negotiate CBAs with representatives of various labor organizations representing district government employees, and they litigate matters on behalf of the executive. The administrative staff supports the director and attorneys and assists in carrying out the agency goals. Their role is absolutely critical in the office's effort to administer an efficient labor relations program, as they are often the first point of contact with employees, management, and labor representatives that we interact with daily. The District of Columbia government's unionized workforce represents approximately 27,000 people, or 75% of its employees. In that regard, OLRCB serves as the executive's principal management advocate in administering the district government's comprehensive labor relations program. It is my sincere belief that positive employee and labor relations is essential to creating a healthy and productive environment. This is why OLRCB's approach is to work collaboratively with our labor partners to enhance operational efficiency while also recognizing and respecting employee rights. In FY24 and FY25 to date, we continued our tradition of regularly meeting and engaging with labor leaders to discuss and develop consensus on a broad range of topics. For example, I've continued to host individual meetings with our labor leaders, which we call coffees with the director. These informal meetings are held in my office. They are one-on-one, and they are designed to be confidential, yet address labor's concerns while also discussing mayoral initiatives. OLRCB also partnered with the DC Department of Human Resources, or DCHR, to engage management and labor through site visits at different agencies under the mayor's personnel authority. We use these site visits to educate the executive teams and upper management and the local union leaders with members at that agency on labor and employee relations. We also carve out time to meet separately, OLRCB, with the union leaders to discuss agency-specific concerns and areas for conciliation. I believe these opportunities to roll up our sleeves and sit side by side with our labor partners advance productive relationships with them. Because collective bargaining compensation agreements are by law effective for a minimum of 3 years, the work of the negotiations section is cyclical in nature, assuming contracts are reopened, negotiated, completed, and implemented as expected. This often results in either a period of numerous completed contracts or a period where the majority of our contracts are simultaneously being renegotiated, approved, and implemented on schedule. OLRCB administers and negotiates 25 separate compensation agreements. I'm pleased to inform you that during FY24, OLRCB negotiated the successor CBA between Washington Teachers Union and the District of Columbia Public Schools. Further, our office finalized a CBA between the American Federation of Government Employees, Local 1403, which represents government attorneys, and the Office of the Attorney General and the Mayor's Office of Legal Counsel in early FY25. We not only negotiated both agreements in record time, but we also continued the prior year's practice of extending the duration of the agreements to better stagger expirations and negotiations over the coming years. allowing for less time at the bargaining table and more time to prepare for budget implications and to align negotiation strategy. The past year's work with the unions is evidence of the mayor's continued commitment to the district workforce to provide first-class compensation and benefits to district government employees. Litigation resources in OLRCB are used in three major areas: arbitration, unfair labor practice cases, and representation issues before PERB. Each attorney in the office carries a litigation caseload and is responsible for all related investigations, pleadings, hearings, evidentiary matters, and appeals to PERB. In FY25 to date, unions have filed fewer ULP complaints, 2 against the district versus 11 ULPs filed against the district during the same time period in FY24. I think this speaks to the efficacy of my team and how much effort district agencies have put into ensuring that managers and supervisors are trained in district government labor law and policy. In FY24, OLRCB began to increase and expand its labor training offerings to district management employees. We facilitated 9 training sessions that provided labor law and policy information, best practices and resources to over 200 management, supervisory, and executive suite district government employees. OLRCB included labor liaison focused training, which is intended for management representatives at the agency level so they can provide immediate guidance on labor matters to the managers and supervisors at their respective agencies. We also facilitated 7 labor relations trainings focused on managing in a unionized environment and just cause to agency managers in FY24. In closing, as we continue to provide high-quality legal services to district government agencies, OLRCB's well-known proactive and collaborative approach in working with our labor partners will remain a constant. We want to build on last year's successes by creating procedures and building partnerships with a vendor to implement a new document management system, iManage, which houses all litigation, negotiations, and advisement documents for each of OLRCB's matters. Having our documents electronically cataloged and fully searchable by OLRCB employees enhances our efficiency, transparency, and accessibility in handling critical document and information essential to our business practices. This better organized and streamlined workflow improves our collaborative interagency decision-making process and will positively impact labor management relationships across the district. OLRCB was able to lean into established relationships with our labor partners in good faith to iron out agreements that have taken years to complete in the past. 2 out of the 3 this year were finalized by the parties alone and without an interest arbitrator's intervention and decision. This level of collaboration with labor speaks volumes to the unyielding effort that we have put into this work. It is my belief that our ongoing investment in renewing and strengthening trust with our labor partners will continue to pay off in FY25 and beyond in ways that we can all be proud of. Thank you again for the opportunity to testify today and to Mayor Bowser for entrusting me to lead OLRCB. I'm eager to answer any questions that you may have.
Thank you. Thank you very much for your testimony. I just wanted to make sure I am understanding on page 7 where you're talking about your new document management system.
Yes.
iManage, is that 2 years old, the system, or is it older?
So sitting at the table with me is my chief of staff, Aisha Alt, and I'm going to defer that question.
Right.
Thank you.
Thank you.
Good morning, Madam Chairwoman.
Good morning.
Just a question for clarification. Do you mean is the system new to us for 2 years, or is it a new system outright in the universe?
With you, of course.
Yes, this is the 2nd year.
All right, okay. Because before you were pointing out that you're building on last year's success, I was wondering if we needed to talk about whether or not you needed to upgrade your catalog system, because that has to be a consideration as we're thinking in the next round of opportunities to talk with you called budget. So I just want to make sure that we know where we may have to go.
Sure.
Thank you.
Thank you for that. When you mentioned that you assist the PERB, you provide support for the PERB in their whatever their caseload is. Not that your attorneys, whatever, define for us what kind of assistance you give to the PERB?
We don't give any assistance to PERB. I don't, did I say that?
Well, you kind of talked about your litigation unit is focused on blah, 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 and then the activities primarily of interest and grievance, blah, and then, you review requests.
Oh, you're talking about
Yes.
arbitration review requests. That's litigation that occurs before PERB.
All right.
Yes.
Okay. Thank you for that. And how many of those types of cases do you review before they go to PERB?
Oh, I think, okay. Let me explain the process a little
Okay,
bit. So
thank you.
similar to what you heard from Greg Pemberton, whenever we have a grievance arbitration, and let's say somebody gets fired, that employee through the union has the ability to grieve that termination. Once the employee grieves that termination, usually there's some kind of a hearing by an arbitrator, by a neutral, and we get a decision. Win, lose, or draw on that decision, either party has the ability to ask for PERB to perform what's called an arbitration review request. It's a type of litigation, it's a type of case that occurs at PERB where that decision that was issued by the arbitrator is now challenged before PERB, and PERB will then rule on whether or not that arbitrator's decision will stand.
All right, and I think we also, since you mentioned Pemberton's testimony, he indicated that as of November 2022, the arbitrator is no longer the point of decision, that it actually goes through, I think he was talking about.
The Office of Employee Appeals.
Yeah, OEA, yes.
Right, that is correct.
So help me understand the connection, because we have two agencies that receive grievances and review these grievances, and your office provides support to PERB, but not to OEA?
No, okay.
Yeah.
I know. It's if you're not in it,
It's
it can be
pretty-
very confusing. Let me see if I can
Yes.
make it any clearer.
All right,
Where to begin?
yes.
So in the case in the situation that I gave you, when an employee is terminated, let me go back. Let's say an employee is terminated and that employee is not a member of the union. Okay, let's say it's a non-union member.
Right.
That I believe if there was a law, if it was an adverse action, there was a loss in pay, they were something like that. That employee has a right to take their termination to the Office of Employee Appeals. That's under their exclusive jurisdiction. And so that's where the Office of Employee Appeals comes into play, because employees who are not covered by a CBA, a collective bargaining agreement, take those adverse actions to OEA. Now, in Greg Pemberton and FOP's case, the council decided that discipline was no longer a negotiable subject of bargaining. And as such, those employees, those FOP members, they no longer are able to go to arbitration. So those employees, if they were the target of an adverse action, now must go to OEA, where before they didn't have to go to OEA. Now they must go to OEA because they can't go to an arbitrator because it's no longer a negotiable subject of bargaining and has been eliminated from the collective bargaining agreement.
And therefore, that has something to do with what OEA says, that they can see unionized as well as non-unionized employee cases.
Yes.
Okay. I'm getting there.
It's all right. Take your time.
Very difficult medium to to work within. Thank you for that. So do you have numbers that would indicate to us how frequently your office does the pre-review before a case goes to PERB, let's say in the past year, FY24?
Let me ask a point of clarification on your
Okay.
question. So if let's say if we were representing an agency and we lost the arbitration, okay, there was an arbitration and we lost, we would look at that decision and decide, hey, does this look like something was missed here? And if it was missed, then we file at PERB for an arbitration review request. And the union has the same ability to do the same thing. If they lose, they have the ability to file for PERB to conduct an arbitration review request.
And I think I understand that. What I'm trying to understand is the frequency in which you are assisting PERB. That's what I'm trying to understand.
We're not so much assisting PERB as we're taking cases to them. It's like an appeal. So
Okay.
we don't assist them. We just file the appeal and then let them
All
run
right.
with it.
Okay. So the frequency then that of filing of the appeals.
When you say frequency, are you asking me how many
Yes.
appeals we? Okay.
Numbers.
Did we provide that info? Did we provide, we may have provided some numbers about arbitration review requests, the number of them. And if we didn't, we can certainly get it to you.
All right. Can I get that number if you have not within 10 days, please?
Absolutely.
Okay. That'll help us. Thank you. And then the number of cases in FY '24, and then any cases thus far in '25 where you have supported the NEA HP.
Oh, NEHAP program.
Yes, NEHAP,
Yes,
okay.
you would like us to provide you with some information on?
Yes, yeah.
We can certainly get you any additional numbers.
That would be
Sure.
helpful. Thank you. You mentioned that you administer and negotiate 25 separate compensation agreements. I'm pretty sure we may have asked a question about those.
Mhm.
Can you just make sure that we have a list of those
Yes,
You know,
that we provided, I'm sure.
entities? Yes, I
Absolutely.
believe you have. Yes, of course. And two. So what are your priorities when you are engaged in the collective bargaining agreement negotiations?
The goal is always to reach an agreement. If you're asking about how we prioritize the order, generally speaking, we operate on a first in, first out. We get a request to bargain. Usually those requests come because a CBA is probably going to expire within the next 12 to 16 months. And once we get that request, then we usually we try to get working on getting to negotiations.
All right. Do you have a system or program where each year you set a goal, or every 2 years, every 3 years? I think you indicated that a contract duration the average is 3 years. So every 3 years, do you have a sense of, or can you share with us, let's say what your goal would be for AFG? Would it be different from ASME? Would it be different from FOP? And so to give us some sense of what those types of priorities might be.
Sure. We usually prioritize, again, it's usually first in, first out, but then also on top of that, we work very closely with the agencies where those unions are located or where the unions may have members. And so we usually have usually it's a collaborative effort between OLRCB, we're the lawyers in the deal, we're representing the agency, and then the agency, of course, takes its cue from the mayor and from the city administrator. And so we all sit down at the table every time there's a CBA and try to hammer out what are the priorities here, what are we trying to accomplish, working conditions wise, and then we get to negotiating. We get some level of authority and we get to negotiating. But we always negotiate with the agency at the table with us. They're an invaluable partner to what we do.
All right, and I just want to probe a little more with this.
Sure.
Because we're in a era in our city government where our revenues are not as high as they once were. In fact, CFO has indicated our revenue last year was basically flat. And so we may go up 1% this year, but we certainly will not show hundreds of millions of dollars of surplus as in the past. So in this environment, and you're having to negotiate contracts, is there some directive that says you got to hold the line or, well, they haven't had an increase in 12 years, so we still got to hold the line, or we know we have to give them 20%, just trying to understand the negotiations process without you having to reveal your trade secrets, because
Sure.
I'm sure you have many.
No, we usually we get those cues from the city administrator and his office of budget. And so, I don't think there's any mystery or magic here. When we have a contract that comes up, we go to the city administrator and we say, hey, here's what usually when we go to him, we have a request for bargaining from the union. We probably have already worked on ground rules. And then we also have proposals, right? The union will come to us and say, we want 5% each year for the next 3 years. And I'll take that to the city administrator and say, here's what they're asking us for. What can we do? And that discussion with him and also with the agency sort of dictates where we're going to go with that. Because remember, we're also trying to be sure that whatever we pay is fair. And so if 5% seems out of whack, then we'll start to look and see, well, what are similarly situated employees being paid nationwide? And then we come to our own consensus on, okay, where should we land on this? And again, with the agency sitting there, they also have the expertise to tell us, we know what these employees do. They work for us, and we know what they're paid in other places. And so we use that all to formulate, it's 5% per year, great. That's 15% over 3 years. Well, maybe what we're looking at, and also how well are they paid now, right? You have a situation where employees are the top in the nation, and they're asking for 15%. We need to look at that. Can we afford that? Is that fair? Or, and so all of that analysis occurs over the course of many meetings, over usually months of time, before we even get to the table with the union. Once we go to the table with the union, we have very clear marching orders from the agency as to what they need working conditions wise. We have very clear directive from the city administrator who tells us, yeah, we're not going to do 5%. The best we can do is 4%. Now I go to the table and we get to work to see what we can hammer out.
Thank you for that. I hope people see the intricacies that are necessary to get these agreements. So,
yes,
and how your office has to hold the line.
Yes.
I mean, you have to be a tiger, but a little kitty cat too.
Yeah.
At the same time. That's important. I wanted to know about the PLA. Are you involved in our PLA negotiations at any time?
I'm not familiar with PLA.
Project labor agreements, like, we had a project labor agreements to do the Nationals Stadium out South Capitol.
Yes.
We'll probably have one for, I guess, the disposable of some of the land at RFK Stadium,
Sure.
those 175 acres. And then what about the arena, those big ticket items? Are you in any way involved in that? Because they will include unions. They'll be, from the private sector, but I'm just curious as to the breadth of what your agency can get involved in.
Sure. That falls outside the purview of our agency. We only have purview over DC government employees and agencies that fall under the personnel authority of the mayor. Certainly, from time to time, we'll get questions about the PLAs, we can give some general advice. Then usually we give that to the MOC, and then the MOC will pass that on to the mayor or whatever agency is involved. But the answer to the question is no, we do not negotiate those, nor do we get involved in those.
Okay, you do not negotiate them, but there may be a time when you might be needed to help with the negotiations.
Sure.
Do you ever see that as being
Always,
possibility?
always ready to step in wherever we're asked to step in and contribute to support the district.
All right, we'll talk more with you about the PLA because that is a bona fide government process, you know, and it does affect the bottom line of our government.
Sure.
So. So how many active negotiations will the agency negotiate this year, FY '25?
It's still a moving, it's always a moving target. How many active negotiations will we have in 25?
Yes.
I'm ballparking here, but probably at least 8 to 10.
Wow. All right. Different unions,
Yes.
agreements, yes.
Yes. And keep in mind, please, some of our CBAs are working conditions only. My office does those too. So it's both compensation, there's working conditions, and then there's combined agreements, which cover both.
So when you do working conditions only, I would imagine that a number of grievances are surfaced. You heard earlier about ASME saying that some of their members, although it's a small union, but some of their members have a fear of retaliation, losing their job if they come forward with a complaint. In the negotiations process, working conditions, does that include that kind of situation that might surface from an agency perspective? I know that you're the lawyer for the agency. I understand that.
Right.
But does the agency ever bother to put in working conditions something about that they know is wrong?
No,
They do not.
we do not.
Okay. Like if a door is broken at a recreation center and you can't lock it and there's a hole and cold air is coming in continuously, birds fly in every now and then, maybe a raccoon you have to chase out. You don't get that kind of, and the management knows that the door is broken.
Yeah, those kind of situations are ones, to be honest, we don't like to see. Obviously, we want for our places of employment to be safe, well-staffed, well-lit. But those things to me fall under just management. Those are just good management practices. And so we're always loath to try to include anything like that in the CBA. Because remember, the CBA kind of takes on a life of its own. Once it's in the agreement, you really can't it's difficult to get it out. And so a situation like a broken door or rats or anything like that's something that, when we learn of it, and a lot of times it does happen that a union, well, actually it happens most of the time, a union president will say, we've been complaining about this door for a long time and it's not fixed. Well, when I get that kind of a complaint, the first thing I do is I call the agency and I say, hey, I got a call about the door, what's going on? And then, in my weekly chats or so on with the CA, he might say, what's going on there? And I'll raise it to him. Like, this is a concern that we're hearing from one of our unions. Similarly, sometimes we have meetings with our union presidents with the city administrator, and that will come up directly to him or even to the mayor. Sometimes we're in meetings with the mayor, it'll come up directly with the mayor. That's a management issue that should be dealt with the agency. It's not something that OLRCB should not be involved in those kind of things because those don't belong in the CBA.
I appreciate that. And when you hear those kinds of, or when they surface and you get right on trying to help resolve it, do you hear it the next time there's a negotiation? What I'm trying to understand is, yes, there's a separation of management from your negotiations process, but how frequently do these issues continue, are compounded year after year, and we're not really addressing them? And if we're not addressing them through the management process, how do we get it addressed?
Yeah, the best answer I can give for that question is, let me answer your first question. I don't ever see it coming up year after year after year.
Okay.
If the concern comes up and it's now been taken to the director of that agency, to the city administrator, to the deputy mayor, to the mayor, we're not going to, that's going to be fixed. It's going to be remedied relatively quickly.
All right. Appreciate that.
Sure.
We have heard of slow process as it relates to contract negotiations, like for the Aussie bus drivers, DCPS administrative and paraprofessionals, and the firefighters. What's going on there? I assume they're in your group of 8 to 10. that
They're all
you're-
in the queue.
They're in your queue?
Yes.
Okay. So what's going on there?
They're
The
in the
slowness. Why is it slow with the
So,
firefighters?
I'm actually glad that you raised this. Slow is the CBAs that we've been negotiating over the past few years have all been done in record time. So I think there's this, I think when you look at the statute and the statute lays out a time frame in which these things should be done, that timeline is very difficult to meet just in the current environment. And I couldn't tell you when that statute was passed, but that timeline it's an antiquated timeline. We just don't move that quick. It's almost impossible to move that quickly. And I know this to be true because I'll finish off how I started. We've done the last few CBAs in a record time. I was at the roundtable we did with WTU on their contract. The first thing that their president said was, we got this one done quicker than ever. While we were in the process, though, all I heard was complaints about it was taking too long. And so if you're looking at the statute as a guide for how long does it take to get these done, yes, I would agree. It's very difficult to keep up with the time frame that's in the statute. But at the same time, we use that time wisely to strategize, to get the proper authority, to do our homework so that when we get to the table, we can do it quicker and more efficiently than we did it the last time. And I think that's proven out. If you talk to FOP, if you talk to the last time we did WTU, it was done in record time. The last time we did FOP, it was done in record time. So yeah, I know we have people who are anxious and we have people who say, oh, we're now in that zone where we should be negotiating because the contract expires. The contract may expire. Everybody's always made whole in the end and the contract gets done. And usually when it gets done quicker than we did it the last time.
So your feelings that 6 months is too short of a period to actually negotiate a contract?
Yes.
You'd like to see 10 months? Is that more realistic?
Oh, it's definitely more realistic. And I don't know if I could put a time frame. It's difficult. Some contracts can be done much quicker than others because there's not a lot there that's going to be reopened. In other words, the union's not going to come trying to reopen the whole agreement. A lot of times the union comes and says, listen, we're fine with all the working conditions. We just want to talk money. Oh, okay. Well, if you want to talk money, then we're just talking money. Those can be done quicker. When you get into contract negotiations where there's some contentiousness, they're going to take longer. Where you have a lot of working conditions that the union wants to open up, they're going to take longer.
Okay. I recall a few years ago, the fire department was concerned about its equipment.
Mhm.
And you recall that?
I do.
Okay, and how long did it take to do that contract? Because that was working conditions, equipment, and compensation. It was a big one.
Yes, I'm going to say it. I'm pretty sure I'm right. We did that one in record time compared to how long it took to do the one before that.
So you did that in 6 months,
I
4
bel-
months?
It may have been a little longer than that. I
Okay.
can get you the actual information, but it's when people bring these complaints and they say it's taking too long, I always tell people, listen, this is a negotiation. It requires both parties to work together at the table. There are a million reasons why from time to time a session gets canceled or why we're not meeting this week. or why we don't have the info that the union is looking for today, but we'll get it for you next time. There's a million reasons why those things add time to the negotiations process. And so again, yeah, I think that 6 months is short, but for others, when you're doing just compensation, sometimes 6 months is just fine.
Okay. That's good to know, because you mentioned the statute, and we probably do need to look at the time frame
Sure.
as prescribed in the statute.
If I could add to that answer too, though, there's also the issue, which nobody ever wants to talk about, is there's always the budget, right? Understanding the budget and the cycles of the budget are paramount to getting this process done. In other words, you know, sometimes it's difficult to actually budget for it because you just don't know how much money is going to be available. As you led off with, you know, we know revenues remain flat. And so that always requires us to, you know, shift on the fly. It may require us to do some things differently just because the budget changes and the numbers change.
So how can we as a government better inform our employees of this thing called the budget and the big effects it has on a contract?
Mhm.
I mean, how do we, I mean, do we hold presentations with them, with their membership? I mean, what is a good way? Because a lot of people, they say, I want my money. I haven't had a pay increase in 10 years. And, you know, you're asking me to do more, you know, I want my money. You know, I hear that
Mhm.
sometimes in our office.
I
People-
believe it's incumbent on union leadership to inform its members of all the information that they gain when they talk to me, the mayor, the city administrator. Be transparent with your members. We have meetings all the time, and I talk to my union presidents all the time. And I'm sure they will tell you, like, I don't lie to them. I will tell them this is going to take longer than we thought. We're not going to have the budget for this. Sometimes that information doesn't get to the membership, or when it gets to the membership, they're not listening to it in the same way, so they see it differently. So I'm glad to educate union members if I'm asked to do it, but I feel like that's really incumbent on the union leadership to do that.
All right. Thank you for that. This is probably inside ball game, but on the average, how many counter offers do the parties go back and forth about before the other party declares an impasse?
Depends on what the topic is. Sometimes it could be 1, it could be 10, it could be 50. We try to work to get resolution. To get to resolution, though, there are a lot of no's. You know, you put forth a proposal as a no. Here's what we can do, and then you get another proposal back. That's what we do at sessions. You know, I actually ideally, when we come to the table for a negotiation session, that's what we want to hear. We want this, and I can do this, and we go back and forth, and we caucus, and by the end of the session, you've come to that middle ground. That's what we like to see. That's an effective negotiation.
So if I were a union, I'd say, oh, I want 32% salary increase because they're getting it across the nation. People who are doing what I do or we do, and I'm insisting. So how do we bring that down to 12%? Or is that an impossibility?
Oh, no, it's not possible. First thing we do is we ask them, we'll prove it up. If you have other employees that you know that are working wherever, show us. Give us your data. Let us see it. Somebody asked for 32%. That's not
They're
even.
not serious.
They're not serious. But we've had negotiations where people come to the table with some ridiculous numbers, and we eventually get there. Sometimes it takes us to get to that last day and say, you know what, that's it. We can't move any further. You're going to stay on 20, and I've already put 5% on the table, which we're already stretching to do. I can't do any more. We're at impasse. And then we go through the impasse mechanism.
All right. Can you provide your negotiation schedule dates as they're confirmed? For instance, if you're working with a union now, I know you just finished as an example, like the teachers union, if you could inform us and say we're beginning negotiations with WTU, if you could do that, and
Sure.
then maybe a notice that says we completed that and paperwork is moving forward or something like that.
Sure.
That would be very helpful.
No problem.
We want to have a little labor section in our newsletter where we put that information out.
Okay.
We have a readership of more than 30,000.
Wow.
So we want to keep people informed.
Understood.
Okay, thank you very much. And how many are you working with now? 4 different unions now?
Oh,
That have negotiations, you're in negotiations with?
yeah, we're probably at the table right now with 4.
4.
4, yeah.
What is the frequency of when grievances lead to arbitration?
A lot, most of the time. It's very rare that either party gets an arbitration decision and they're willing to live with it. So usually that requires us to then file for an arbitration review request at PERB, so the PERB can review it almost like an appeal to see whether or not the arbitrator missed anything.
Okay, so you file with PERB frequently?
Well, that's the only place we can go.
Yes,
And
yeah.
if we feel like the case requires a second look, then yes, we'll go there.
All right. And so can you send to us within 10 days the number of filings that you had to do in FY '24?
Okay.
That'll give us I don't know if you have had any negotiations during that year, but if you did, that would be very helpful.
Sure.
So does your office monitor and enforce contract provisions across government agencies?
Absolutely.
How do you do that?
Oh, and how do we enforce
I mean,
it?
do you have an the enforcement ability built into the work of your agency?
Well,
I mean, you
When you
can't fine them. You can't levy fines. That's what I'm
No.
trying to get to.
no. We use the legal process. If we
Okay.
have to enforce a CBA, usually any kind of enforcement of a CBA requires either some kind of a grievance or arbitration, or it's a case that goes to PERB.
All right. So that's how you do it. All
Mhm.
right. So you cannot advocate for the removal of a union personnel
No.
or
no,
leadership.
That's actually illegal.
Want it on the record. Thank you.
Yes, absolutely.
There are numerous CBAs that continue to be in effect that they've expired.
Mhm.
So are there any consequences for the CBA to still be applied even though it's technically expired?
No. The
Okay.
parties understand when they execute it that that's the agreement that they'll have until another one comes about.
Okay. And so therefore, there are no legal claims that someone can make or to sue the government when the CBA is not legal?
No.
Okay. All right. Can you talk to us a minute about the purpose of an interest arbitration hearing? We know that the FOP may be at that level in their negotiations, so that we're clear what that really means.
Sure. Interest arbitration occurs. Allow me to give examples. I think it's easier when I give examples.
Yes, thank
So
you.
let's say you have agency A and they have a union and they're negotiating a contract. To use your example, the union comes and says they want 30%. We tell them we can give them 3%. And we go back and forth over months or weeks or whatever. Eventually you get to a point like we discussed earlier where maybe they'll come down to 15. I'm at 5. We're very far apart. And so the statute has a mechanism in place for what we call impasse. because we are at negotiations impasse. And so what happens is we make our last best offer, my 5, and they make their last best offer, their 15. Now we're at impasse. The parties file for impasse mechanism at PERB. It's a process by which an arbitrator is selected. The arbitrator takes testimony at a hearing. Typically at that hearing, the arbitrator will hear witnesses that will talk about what's fair in the marketplace for that kind of job, why it is that the parties have staked out the positions of 5 and 15, what bolsters that. And then an arbitrator makes a ruling. And that arbitrator has to pick one of those last best and final offers. The arbitrator cannot, on her own or his own, say, 10 sounds fair. No, that's not how it works. The arbitrator has to pick one. And once that's picked, that is now, the arbitrator basically writes the contract, and that's the final word on it. The union gets whatever, then we have to pay whatever it is that the arbitrator says we have to pay.
Okay, so primarily, interest arbitration is about compensation. Is it ever about working conditions?
Yes.
And so if I say I need, my union needs, we work on average 10 hours a day, and we need 3 breaks in the 10 hours.
Mhm.
And let's say the agency is saying, well, we can't do 3, only 2. You're saying one of those, the 3 or the 2 will be selected in this setting.
That's correct.
Okay.
Well, we're oversimplifying it.
Of
but,
course.
I'm gonna pass it to my
All right, okay.
chief here. I think she can answer better than I
All
can.
right.
Thank you, Director. Non-compensation or working conditions is a little bit different. In those instances, the arbitrator can do a hodgepodge. They can take the best proposals from management and the best proposals from the union and craft something a little bit different. Unlike compensation, on compensation, they have to pick either one proposal, last best final offer, or the other.
Thank you. We'll be talking with PERB about that when I can hardly wait to talk with them about how they do that. Thank you so much. At the end of last year, that's FY24, the agency received a final report entitled Compensation Analysis for MPD, FOP, FY24-26 Collective Bargaining Agreement Negotiations Report. Can you share with us generally the group's consulting's findings?
I would prefer to discuss that in private, as
All
that's
right,
still an
okay.
active litigation.
Ah,
Yeah.
I got you, if it's an active litigation. All right, thank you. What financial tools are used to assess the sustainability of salaries and benefit increases?
Sure, that falls on DCHR.
All right.
I
We
don't run
keep
that.
hitting all of these agencies that are in this committee. You're giving us more. It's the way of life, I understand. Almost done. Last year, the agency looked to hire an in-house economist to help bolster your efficiency in negotiations. Can you describe the role of that personnel and how would they collaborate with the budget office? Is the second part of the question, and how they aid in producing quicker counter offers. I assume they would be engaged in that.
Sure. Ms. Alt's got the answer for this.
Thank you. And so your first question, Chairperson, is the role of the labor economist.
Yes.
This Comprehensive Merit Personnel Act, the CMPA, has a standard that sets out what compensation should look like for district government employees. And two things that we have to look at is competitiveness with other jurisdictions. Now, for right now, it's nationally, and then also, competitiveness, and then which jurisdictions we compare ourselves to. So the role of the labor economist is to kind of guide us when it comes to those two questions. So they would do the research and determine based on which collective bargaining agreement or which agency and union they're looking at, the types of positions, what other people in similarly situated jurisdictions are being paid for those positions, and then give us guidance on where we should fall per se when it comes to negotiations. What's a fair compensation package look like? And that's wages, but also benefits, et cetera, anything dealing with compensation. And how they would liaise with the budget office is just to take a step back. Part of what we do now, how we rely on the Office of the Budget, the CA's office, and also DCHR, they're the ones who do a lot of that analysis for us for collective bargaining agreements that we do, that we don't use the third-party consultant to work with us on that. And so typically what happens is we reach out to the budget office and ask their folks to cost out the proposals, the compensation proposals, et cetera, and DCHR does the analysis and research for the comparators, where we should be looking to compare ourselves to. So this person will work with the budget office. They would already have the research done, and they may be able to assist with costing out as well. So taking that load off of the budget office and bringing it in-house. And this would be more cost efficient. I believe that was your third question.
Yes, as it relates to counter offers.
To counter offers,
Mr. Maxwell wants to answer that.
I got it.
Please.
Okay. It sort of follows the same pattern. Right? We're at the table and we're going back and forth. Maybe after a session, we get an offer, which is maybe outside of the authority that I have. We'll take that offer back to the CA and see if there's any way we can make that work. And we do that again in conjunction with the partnership with budget office and the agency, because the agency has to be able to afford it. And the budget office has to be able to provide those funds, and DCHR tells us whether or not it's fair.
So are you informing us that this position is very necessary for the work that your office does?
It is. It's vital because we don't have that kind of expertise in-house right now. And so to get it, we have to, as the chief said, we have to put together this hodgepodge between budget, DCHR, sometimes use a third party depending on what unit is. But if we were able to have that expertise in-house, it would save us money and time.
All right, we'll be working on it.
Thank you, ma'am.
Mhm. And you'll give me some general ballpark.
Yes.
I mean, we're not talking about 1.5 million, are we?
No.
Okay.
I promise.
Thank you.
We won't pay them that much.
Okay. But you do desire to fill such a position,
We do.
if possible.
Absolutely.
Okay, thank you. Ground rules, which is that area where you, at the beginning of a negotiation, is so important. Is there anything in DC law or in the statute that stipulates that a negotiation cannot begin until ground rules are received from the negotiating parties?
There's no such law. In fact, I believe there's case law from PERB which says almost the opposite, which is that you can proceed without ground rules. It's not a subject that you can go to impasse over. So in other words, if we insist on ground rules, at some point we're going to be ordered to move forward and negotiate in good faith, even if we don't have them.
So where did this term ground rules come from, if it's not a requirement?
It's a generally accepted practice in labor law that when you sit down to the table to negotiate a union contract, you start with ground rules. Why do you start with ground rules? So that you understand that when you show up to negotiate a contract, the same people are at the table. You don't want different people showing up at the table every time. It also limits usually the number of people. It is an ineffective use of everyone's time to show up to a negotiation. For me to show up with 40 people with me, we won't get anywhere that way. Also, the ground rules speak to the frequency, right? How often are we going to meet? Weekly, monthly, every 2 weeks? how are we gonna do proposals? Right now, I would say it's usually generally accepted practice that proposals are done using Microsoft Word or some other tool, and that allows us the ability to see where changes have been made and to track those changes and to make comments. And usually in a good negotiation, a party shows up with the contract redlined with all of their changes, and they push it across the table, and then we make changes to that. So the ground rules speak to that process. When you don't have it, sometimes you show up to a negotiation session and somebody just throws a piece of paper at you. We want to make a change to this article. Here's the change. Well, it's not been incorporated into the rest of the document, so it makes it very difficult for us to be able to track what's going on with the full contract. So when you ask about ground rules, I see them as essential. I would, it's terrible to go to the table for negotiation without ground rules, but it's not required in the statute. It's just good practice.
Good practice. And is there an opportunity perhaps to stipulate that we would have ground rules? And ground rules must take effect after third negotiation session. And that gives the parties, and in the event there are no ground rules at the very beginning, it would give you an opportunity to maybe through the proceedings of the first couple of meetings to fashion something that works, as you said, that, okay, this is a different group at the first meeting, second meeting, different parties at the table. Okay, when we meet third time, whoever's there, we need to make sure we know who we're negotiating with or who the negotiating parties are, as a standard kind of approach to it.
Yes. And I would say that 99% of the time we have ground rules because it benefits both parties.
All right, so if it benefits and we have it, is there any constitutional reason for not having ground rules as a law in our government?
I don't want to speak out of turn. If I can get back to you on an answer to that, I want to be sure before I say yes, we should make that change. I'm not familiar enough with the law to be able to say, yes, it's not going to affect constitutionally anything else. So let me check that out and we will get back to you. But we insist on ground rules.
Thank you. I think this is a very important area. Thank you very much.
Sure.
Well, thank you very much, Mr. Maxwell and your team. And thank you for having your team here with us today.
Sure.
And we look forward to talking more with you on budget matters in 6 weeks.
All right. Well, thank you very much, Chairperson, for your time. As always, you and your staff have been fantastic, and we love working with you. Need anything, please let us know.
Thank you so much.
Thanks.
All right. Next, we will hear from the Public Employee Relations Board. All right. Thank you. Thank you very much. I know the public has heard a little bit this morning about the Public Employee Relations Board, but it is an impartial, quasi-judicial, independent agency that resolves labor management disputes between agencies of the district government and labor organizations representing agency employees. The board consists of 5 members, which are appointed by the mayor with the advice and consent of the DC Council. The board is responsible for numerous matters such as certifying and decertifying labor organizations as exclusive bargaining representatives, adjudicating unfair labor practice complaints, considering appeals of grievance arbitration awards, and facilitating the resolution of impasses and contract negotiations, just to name a few. Now have poised before us the Executive Director, Mr. Sims. And now let me swear you in. If you will raise your right hand. Do you swear and affirm that your testimony and any statements that you make before us today to be complete and truthful?
I do.
Thank you and welcome. And I think we're welcoming you as a new father, if I
Yes,
remember correctly.
thank you.
Mr. Sims.
Good morning, Chairperson Bonds and members of the committee. My name is Royale Sims, and I am the Executive Director of the Public Employee Relations Board. PERB is an independent quasi-judicial agency that resolves labor management disputes involving agencies of the District of Columbia, labor organizations, or individual employees of district government agencies. The 5-member board was created pursuant to Section 501 of the District of Columbia Comprehensive Merit Personnel Act of 1979. The CMPA empowers the board to 1, determine appropriate compensation and non-compensation bargaining units, 2, certify and decertify labor organizations as exclusive bargaining representatives, 3, adjudicate unfair labor practice complaints, 4, consider appeals of grievance arbitration awards, 5, investigate the standards of conduct, 6, determine whether a particular subject or proposal is within the scope of the duty to bargain, 7, facilitate the resolution of impasses in contract negotiations, and finally, 8, adopt rules and regulations for conducting the business of the board. Consistent with these responsibilities, the board is authorized to issue subpoenas, conduct hearings, seek judicial enforcement of its orders, and retain independent legal counsel to represent its interests. In FY24, the board held 11 monthly meetings and issued a total of 35 decisions. PERB opened 101 new cases, conducted 38 mediations, and closed 69 cases. This is a great increase compared to FY23, where the board opened 35 cases and closed 42 cases. PERB has continued to provide training to the district's labor relations community through its second Tuesdays at PERB program. These trainings are conducted through a virtual format. In FY24, PERB held 9 training sessions. PERB has consistently demonstrated its ability to produce well-reasoned, legally sound decisions. In FY24, the Superior Court remanded one matter to PERB that concerned the retroactive application of a statute rather than any deficiency in PERB's reasoning. In FY25, PERB will continue to provide high-level service to the district and the labor relations community. Thank you for the opportunity today to report on PERB's performance. And at this time, I will be happy to answer and respond to any questions.
Thank you very much for your testimony. I wanted to, you are a 5-member board. Do you have all of your positions filled? Finally?
No.
No.
We currently have 4 members. Our chairperson is a holdover, so his term expired in December. The board is required to have a quorum of 3. So unless the chairperson and the vacancy are filled, we will be down to our 3 members.
All right. And is your board, do your members receive compensation?
Yes.
Have you had conversations with the Mayor's Office of Talent to determine whether or not there are those who are interested in being on the board and may therefore there be some action soon regarding the vacancy?
Oh, we hope so. We have followed up with the Mayor's Office of Talent and Appointments, and our board has recommended a name to fill
Okay.
the current vacancy. We haven't had a chance to discuss the upcoming vacancy, though.
All right. And would you let me know where you are on getting a response from the mayor's office on your recommendation, and also how you're going to address the issue of your chairperson's holdover, or just how that might be handled?
Will do.
All right, thank you. Within a week, can I hear back so that we can move to be of assistance as needed?
Yes.
I'll start with the fact that you are now at a new location, correct? Your office moved?
Yes, we were located at South Capitol Street, 1100 4th Street. And now we're located at 899 North Capitol.
Is the move a better situation for you?
I think the offices provide us with a lot of opportunity. The transition happened very smoothly. There are a few lingering issues, but for the most part, I think it is a great location. One thing that we've noticed, though, in planning, we hadn't experienced the increase in caseload, and so our office may be smaller than the potential staff that we need. So it may be too small for us very soon.
What is your staff count?
Currently, we have seven employees, including myself. We have 8, so we have 1 vacancy. 3 attorneys on staff. Well, I should say 4. I'm an attorney also. And then 3 administrative staff.
Okay. And your caseload, I'm noting what you reported to us as your caseload for FY '24. You had 101 new cases.
Yes.
And is that an increase over FY '23?
Yes. In FY '23, we had 35 new cases filed, so it's nearly
Can-
tripled.
Yes, yes. What is the trend amongst the new cases? What are the concerns?
It's a variety of cases. I think we've seen an increase in negotiability questions, which typically ebbs and flows with the parties bargaining of CBAs. We also saw an increase in standard of conduct complaints. Those are complaints filed by union members against their representative organizations concerning the adherence to the standard of conduct. And then we also saw an increase in unfair labor practice cases. So pretty much across the board, we saw increases in cases. I think as we resolve issues, that will create case law, and the parties will have references to look at when they encounter new issues, and so we may see less of those type of cases. But we expect we think this is getting back to pre-COVID levels, where this is typically our normal caseload, and we previously had 4 attorneys with this amount of cases.
Okay, you mentioned that questions about conduct. Can you give me an example of what kind of case that might be?
Yeah, so the standard of conduct is a standard that all labor organizations in the district company must abide by. So in order to be an approved labor organization, you have certain standards that you have to follow. Being transparent with your financials, being having fiduciary responsibility, representing members without discrimination, and those standards are not for the employees; they're for the unions. And so, if a union refused to open up its books and the member requested to review transactions, credit card statements, checks, those things, and they were denied, they would be able to come to PERB and say, my union is not adhering to the standards of conduct.
Okay, and then for illegal practices, what give us an example of that?
So in labor law, there are kind of like distinctions between like an unfair labor practice or in subjects of bargaining, there are things that you could be permissive subjects of bargaining or illegal subjects of bargaining. An illegal subject of bargaining would be something that like a party would propose some type of racial test in hiring decisions for the collective bargaining agreement. So that would be illegal. And an illegal practice, I guess, well, does that answer your question concerning like illegal?
Well, I mean, you could, if you want to give us a little more, I'm just trying to understand the nature of the complaints that are before you. Because I've heard a lot this morning that implies that OEA may have a real overload. And then I read where you present us with abundance of new cases. And looks like you're moving along rather swiftly. And so just curious about the differences in the agencies and the workload. Trying to figure out how, if we can, make it a little easier for employees and unions to get a decision on any of their concerns.
So I guess the cases that we have are focused on the collective bargaining relationships between the parties, and so not necessarily illegal. So of course there are things prohibited. So unfair labor practices are prohibited under the District of Columbia statute, and that could include like a refusal to bargain with a union, or it could include interference with an individual's right to join or refrain from union activity. So we see a variety of subjects. I think the key to processing cases at PERB is, our staff and our ability to receive issues or receive complaints, understand what the complaints are, enter them into our process, which typically includes a mediation. If mediation is unsuccessful, then a hearing if there are factual issues, and then ultimately a board decision. So to address some of those bottlenecks, we have sought to expand our core of contracted mediators and hearing examiners. And then on the other end of that is providing the board with decisions and orders. And so that's where our staff attorneys come into play. And so if we're able to process cases with an expanded core of hearing examiners and mediators, then we also have our current number of attorneys processing those cases as well. So my concern is that, we may get more decisions at the front end, but not be able to process them as quickly on the back end.
I hear you saying, don't give me more work. I got that. But what?
Oh, no, we will take as much work as you can, as much work as you're willing to give us, and the staff and the appropriate staff to accompany it.
Right, right. But I'm also learning that a lot of your work is done with consultants, the attorneys that you hire. So therefore, you really, while you may see yourself as being an 8-member office, you really could be 12, and that may help in the workload. clearing out the workload? That's what I'm trying to understand.
Yeah, I think an expanded core of mediators and hearing examiners, those are our main contractual positions. They help us move the cases along. So, mediation is a voluntary process where the labor organization and the agency come together at PERB to, really work on solutions. I think we have really good mediators, but it's not always successful. There was a point last year where we had more hearings than capacity with our hearing examiners. So there's a bit of a bottleneck. And so we're constantly right now we're recruiting more hearing examiners so that we can kind of strengthen that pipeline.
All right. Can you make sure that we get in our office a copy? Do you advertise these positions?
Yes,
Okay. Can we get a copy of the advertisement for these positions, mediators and examiners?
yes. We have it posted on our website, and we've reached out to a variety of organizations that have mediators and arbitrators, and we'll provide that.
Right, right. And could you, in providing us with a copy of the hiring document, could you also share with us some of the specific duties that these individuals would perform? I think that would, when you say mediator, that one thing comes to mind.
Mhm.
When you say examiners, I'm assuming that they're investigators. I don't know that they are. But
Okay.
something that would be a job description of sorts that would help us understand what you are looking for, and more importantly, how you're able to manage all these cases. It
We'll-
could be helpful maybe to some of the other agencies as they're trying to get through their extensive workload.
We'll do.
Are you aware that when you do a Google search on PERB, the address still shows 4th Street Southwest?
I was not aware of that on Google. We have updated it on our website, and so we can look
Okay.
into that.
Please, because that's how we'll get to your website, through the internet. Okay. And we certainly do not want it to have an adverse effect on the filings of cases. When you think about your board members, what are the biggest challenges that your office faces in resolving disputes? I'll say quickly.
From the board's perspective, I don't think there are many challenges. I think the board is very experienced, and they provide well-reasoned discussion and decisions. They work very collaboratively, and I think they help the agency identify issues for final decision, and make sure that the products that we produce are understandable by the public and inform the party of the reasoning behind the decisions.
Unfair labor practice complaints tend to take time to process. And currently, you have 12 claims that have remained open for more than 200 days. What's going on, and how do you plan on resolving them, if ever, and what's your time frame?
So for cases that involve a hearing, our goal is to have them out of our office within 300 days. We're running a little bit higher than that, a year average, so like 360 days. there are a variety of reasons why those cases take longer through the entire process. So this includes mediation, fact-finding, and then the final decision. The parties in many of these cases have requested extensions of time or more than one mediation session. And so, we're very flexible in allowing the parties, especially during mediation, to kind of craft the timeline because at that point they're trying to reach an agreement without a third party's intervention. And that typically produces a longer timeline for those type of cases.
So do you have within your operating rules an indication as to when you must reach a deadline on these cases? 500 days, 900 days, 300 days? What is it? Or
So
do you have that?
it's in it statutorily, a case must be decided within 120 days after it's presented to the board. There's a lot of time before a case is actually presented to the board and agendized. And so, that's where flexibility and allowing the parties to kind of craft their agreements at mediation happens. But once it's presented to the board, it's always within 120 days. So if it's on the board agenda, it's going to be a published decision in the DC Register before that 120-day mark.
So do you receive or entertain complaints from agencies or individuals that you're taking too long or that they would like a decision? When I think of 300 days, we're now talking the year. When 120 days, you say there's a pretty lengthy process that you go to before the package gets to the board. So could be 400 days. We're now into the second year since the filing. Do you have a sense of the average number of days it takes to really go through your process, or are all of your processes at least 300 days?
So some processes that do not require a hearing are typically expedited, expedited, I'm sorry. So for instance, our arbitration review requests, that's a decision on the record. The board has a narrow standard that we review. And so that's typically between 90 and 120 days. Negotiability appeals, we usually do not have to have a hearing in negotiability appeals. And so those are typically turned over a little quicker within 120 days. But those cases that have to have a hearing, it's almost built in that case will last 300 days from the mediation to the scheduling of a hearing to the filing of briefs to the filing of exceptions following the hearing examiner's decision. Those are 30 to 60-day periods where it's once you have a matter that's going to a hearing, you can expect it within the 300-day time frame.
Have you done a comparison about the time that it takes to go through your process in comparison to the time it takes for an individual to go to Superior Court or District Court? Just curious.
No, we haven't. Compared to other labor relations boards like the FLRA, the NLRB, I think PERB's process is a lot faster. But we haven't done that official comparison.
I guess I'm just struck by earlier testimony from the public where the issue is the longer the resolution takes in a case, the longer the individual may be without income. And so I'm just trying to understand how we, through PERB, might be affecting situations, but your cases are really primarily against a union as opposed to hearing individual cases. Am I correct?
Yeah, so our cases
Okay.
typically involve unions and agencies. They can involve issues that impact individuals.
individual.
If there's a unfair labor practice or even our arbitration review requests. Many times, an arbitration review request is a follow-on case from a termination that was grieved, that proceeded to arbitration, and an agency is exercising its appeal rights, which puts it at PERB. And then the agency may further exercise appeal rights from PERB and go to Superior Court. And so, in some ways, timelines and the impact on individuals is affected by, the exercising of those rights. But, I don't think there's a solution that could I don't think there's a solution to that issue where parties have that legal right to move forward and appeal.
So you have told me today that exercising my legal rights take a decade. I got it. You haven't told me that, but you know what I mean. It takes time.
It has happened in cases. We have seen cases where there's, parties appeal and appeal and appeal, and sometimes the appeal goes both ways, where it's 5 years, 10 years. And, I think the board does take that seriously. In our meetings, when the board reviews these records where these cases have taken so long, they ask, why is this being appealed? And, I think in the context of arbitration, the board has, provided language in its orders to, address what they see as bad faith efforts. And they've ordered cost to parties that when they find that the appeal has been frivolous. But the board is also limited in the remedies that we could provide statutorily in certain instances. So a party may request attorney fees or other penalties, but the board is limited in that respect in the context of arbitration.
All right. So with you today, do you have any data that would inform us as to the number of cases in FY23 and then number of cases in FY24 that were presented, but upon first review, you just dismissed them or did not accept them to move forward? Of the total number of cases that you received in those years?
I can provide that. I do not have that with me, but we can provide that.
All right. That would be helpful. Your outside counsels who do the, make sure I've got it right, mediation and the examinations, do they produce formal writings? Do they provide your office with written documentation of their findings?
So yes, so I think is a bit of a term that to address. So our outside counsel is our legal counsel for our Superior Court appeals, but our contractors are our hearing examiners and mediators, and they do provide written documents. So our mediators provide a mediation report to the agency following mediation, and our hearing examiners provide a report and recommendations. So they take the facts and the evidence of the parties, and they operate much like administrative law judges. And then they provide a report and recommendation to the board, which we review to see if it's reasonable and consistent with the board's precedent.
But the outside counsels work in tandem with your counsels, I presume, in a court case.
Yes, so I manage the outside counsel, and they represent PERB following an appeal of our decisions from the board.
All right, so they do not provide a report.
No.
Okay. They work hand in hand with whatever your team is that's on that case, or they just go into court representing PERB.
We work well with our outside counsel. They represent us in court cases. They file our briefs. They communicate the agency's position on appeal.
Okay, and so the briefs that they file are produced by your office or by these outside counsel?
The briefs filed in Superior Court are produced by outside counsel.
All right, so you retain a copy of that brief in your office, in your files?
Yes, we have files of the court cases.
Yes.
Yes.
Okay, thank you. Do you have an email filing option?
We have electronic filing.
Okay,
So parties, we have a vendor File and Serve Express. Parties file through that portal, and they are able to both file and be served documents electronically.
okay. If there is a dispute on a contract term of a collective bargaining agreement, what body would the individual turn to? You, OEA, Superior Court?
It depends. So at the base level, if the dispute is about the interpretation of the agreement, the parties would typically file a grievance and proceed to arbitration. If the dispute is about a violation of the statute, so a refusal to bargain or interference with a contract, so even repudiation of agreement. So say the agency took some action and the union claims that it totally violates the agreement to the point it ignores the agreement completely, they would proceed to PERB. There are some remedies where, well, for most contract CBA remedies, PERB is for most statutory violations, PERB is the answer. To avoid arbitration, a matter may be taken to the Superior Court. And then for OEA's jurisdiction, typically does not overlap with PERBs. PERB is more labor relations and OEA is more employment relations.
So what mechanisms are in place to review and update the board's policies based on evolving labor laws and workplace trends? And to that question, I'll add, and given the anxiety, concerns that are being expressed by labor in the federal government do you see spillover? Or have you heard from our local labor unions about what are you going to do about this when you know it's going to come to you, that kind of stuff, when it probably doesn't come to you, but I'm sure you're getting that kind of questioning.
I think the environment has created some tension and concern. I would pause to provide any comments on things that may come to PERB and PERB's potential reaction. There are several mechanisms to update, the board's procedures and responses to workplace trends or evolving labor law. Primarily, the board is case law driven. And so if there are major changes in the standards for labor law, the board often looks to the FLRA or the National Labor Relations Board and other boards. Then if there's a major shift, that may influence the board's outcome. It may cause a change in precedent. The parties are primarily responsible for bringing those issues to the board's attention. And so if there's a major shift in case law, for example, the right line test is a test used to determine whether or not agency adverse action was based on was discriminatory. So, was this adverse action based on someone's labor involvement? So there's oftentimes shift in the right line test at the National Labor Relations Board. And most recently, there was this intertape decision that came down from the NLRB that has influenced the board's decisions and has been cited to by the board in their recent decisions. So as an agency, we're primarily case law driven. Our changes will occur in case law. As an administrative agency, our precedent is more flexible and can change in response to those decisions. The second mechanism is rulemaking. So if the board notices something is if the board notices that there's an issue that needs to be clearer, it can always issue rules to define the issue, define standards for the labor relations community.
Okay, so in both of those examples, is the board independent of the DC government operations? I know you're an independent entity, but what I'm trying to understand is those decisions that you make, let's say rule changes, maybe even having to explore how you handle DEI as an example, or look at it from your perspective. Is that something that has to go to the mayor, city administrator, or is that something that you can decide as a board and then operate under the new premise that you've established?
So the board is an independent agency, but we are subject to some of the same safeguards as other administrative agencies. So the Administrative Procedure Act, notice and comment rulemaking, the board is authorized to issue rules. And so we would follow the Administrative Procedure Act to provide the public with appropriate notice, receive comments, and then issue those rules.
All right. I wanted that on the record because I did not want for a minute any of our unions and employees to think that, oh, there may be some arbitrary decisions being made based on some newness from somewhere, and we do not have, a higher order. That's what's important in my opinion in government. So I appreciate your response to that, putting it on the record. We've heard that the grievance process may be used as a tool to delay resolutions and to deplete union funds. Have you been able to identify any such issues in any of the cases over, I'll say, starting in FY 23, 24 to date? And remember,
So-
could talk a little bit more about the 12 cases, 200 days longer. Is that a stalling?
So I hesitate to say that cases are used as delay tactics to, drain union resources. Even if cases can take a long time, and they do have a economic impact on unions and the parties and both parties. As I stated, when the board senses that a case is filed in bad faith, they do provide additional remedies to the extent of our remedial power. And they do make those comments in their decisions and orders. We can provide copies of those cases and those issues to the committee so that you all can see some situations where those remedies have been provided. But ultimately, we tend to have faith. We tend to believe that the parties are exercising in good faith their legal rights. And I think as a neutral body, you have to start from that point to say that these parties are acting in good faith unless you're provided evidence to the contrary.
So how would you collect evidence to prove that this is a delay tactic on purpose?
Well, I think in some cases we have seen a number of cases filed where the arguments are repetitive and the same arguments have been repeatedly rejected by the board and repeatedly rejected on appeal. And that may show some frivolousness. And so in those situations, I think the board has, to the extent of its remedial power, provided additional remedies.
All right, well, we would certainly be curious about an example or two. Got to redact the name though, so I don't, okay, that would be helpful. What happens to PERB's open, excuse me, open cases regarding active negotiation complaints once a collective bargaining agreement is reached? Is the case then dismissed? Or do you continue for 200, 300, 400 days?
So our cases that involve negotiability disputes typically do not last that long unless they have been, in some instances, we had a consolidated case. So instead of being just one negotiability case, it was 4 or 5 negotiability cases. And so that could take a little longer to process. But we typically aim to resolve negotiability disputes within 120 days.
Well, let's say that the agreement is reached, you're 90 days into looking at the filing
Mhm.
and the agreement with that union is reached, do you then notify the party that, you know, we will cease operation of looking at your case because an agreement has been reached?
It would depend. That reaching an agreement could very well moot the case, but it could be an issue where the parties are seeking a determination for. Well, let me pause. So it could very well be that the case will be moot. Typically, in that situation, parties would withdraw the negotiability dispute in consent.
So do you
as
send them a
resolved.
letter asking them, letting them know now that your union has reached an agreement, the union you're a party to, this is a letter inviting you to withdraw your case from PERB?
Typically, the parties would proactively provide that withdrawal. PERB is not privy to like the day-to-day movement of a negotiation. So things can change without PERB knowing it. And so, we reach out decisions on our timeline as quickly as possible. But if there's a dramatic shift in the parties' positions, they typically take the step of informing PERB of that change.
So perhaps then the Office of Labor Relations needs to notify you each time that they have reached an agreement with a union, and then we can expedite. It's just a bit concerning, the time frame that it takes to get through the decision-making process on these filings. And so that's what I'm concerned about. And if it's a staff issue, that's one thing, but I think you kind of made it clear it's not staffing per se, that you have the ability to have, as you call it, your contractors. So you have to have a budget for your contractors. I'm aware of that. And I know you indicated that your space is a bit tight for the number of bodies that may be working on a day-to-day basis. So, and perhaps something can be done about that. And I think last year you had an issue of the amount of rent you had to pay. That was an issue, and we were working on that. So I'm trying to, whatever you're trying to get done that affects the product of the government, that's what we're concerned with, and trying to assist in any way that we can.
Understood.
So when do you hold public meetings, or are all your proceedings subject to the Open Meetings Act?
Yes. So we hold a public hearing monthly. The board does conduct its business virtually. It's usually the third Thursday of every month at 11 o'clock. This month, it will be on the last Wednesday of this month at 11 o'clock. And we are subject to the Open Meetings Act.
Okay. And where can the public access this information? Like, the date and the time, and here's the virtual contact, or do you?
Yes, we post that information on our website.
Okay.
PERB.dc.gov in our current events. And then if you are on, for our other events, like our trainings or our or hearings, we'll send that information to our email list to provide notice to parties.
All right. Does PERB publish annual performance reports?
Our annual performance reports are published on I believe the OCA. I don't want to misspeak on the acronym, but
All right, but then the city
City
administrator.
Administrator's Office has the
Okay.
performance report.
All right. As I mentioned to the Office of Labor Relations, I was wondering, how do you, PERB, ensure compliance with your rulings? And do you have an enforcement mechanism?
Yes, so we seek voluntary compliance at the first stop. Failure to comply is usually raised by the winning party. Um, we have enforcement cases where parties tell us that our ruling has not been complied with. We give the opportunity for the, you know, aggrieved party to provide reasoning why they did not comply with our ruling. And then we're able to petition the Superior Court to enforce our rulings with all of its authority.
Great. Could you send us a list of those such enforcement case filings from FY '24 and to date, FY '25? Are there any instances where a party is mandated to pay the other party's court fees, attorney fees?
So yes, so we have a defined authority to provide for reasonable costs. And then we have a limited authority to provide for attorney's fees. In unfair labor practice cases under the Federal Back Pay Act, PERB is authorized to award attorney fees once it finds that an unfair labor practice or prohibited practice has been committed.
And so it's only in the unfavorable labor practice cases?
Yes.
Okay. All right. Probationary period 8 is deciding whether an employee's knowledge, skills, abilities, and conduct meet requirements. During the time of probationary employees, do they have the same protections or can they file grievances with PERB?
I'm not sure. I think I will have to research that question. Generally, under the statute, employees have certain rights to freely join, assist a union, or refrain from that activity. And so I'm not, and then all employees have the right to file a grievance outside of the labor organization, as long as the labor organizations provide the opportunity to comment on any adjustment. I'm not sure if there are other restrictions on a probationary employee's ability to file with PERB or file a grievance with their labor organization through PERB. That may be in some cases, there are CBA provisions that provide some vesting period, but I'm not sure if that would if that's a question that PERB would have jurisdiction over, or if it's a question that an arbitrator would have jurisdiction over. So we could look into that.
Okay, just, we were very curious about that. Wondering, where does a probationary employee go? Someone who is not yet vested in the system, but is nevertheless in the system. So curious about that.
So, and for us, there may be some easy questions where PERB can clearly exercise jurisdiction if a probationary employee alleges that for a hypothetical, management told me I'm not allowed to join the union. Well, that would be something that implicates the statute of freely forming, joining, assisting, or refraining. Or the opposite end of that, management told me I must join the union. Again, clearly implicates PERB's jurisdiction. And so, your question about grievances, we will have to research to see whether there's a CBA vesting that would, limit jurisdiction.
The type of
If
grievance.
it's for
Mhm.
more for an arbitrator or for PERB.
You mentioned several times arbitrator or PERB. When you say arbitrator, are you saying that this is a independent individual practitioner where an employee can just go to their office, have a chat, and then that individual is working to resolve the case outside of PERB, outside of OEA? Is that what you mean when you say an arbitrator?
Yeah. So typically, no.
Okay.
Typically, arbitration is a third party neutral process. It is outside of PERB. It is outside of the district government, but it originates from the parties' collective bargaining agreement. So parties at arbitration are usually the labor organization and the agency or the agency's representative. And individuals are generally not a party to an individual arbitration. So an individual may file a grievance. That grievance typically would go through the grievance process. And when it turns into an arbitration, so you reach your grievance is denied at step 1, your grievance is denied at step 2, grievance denied at step 3, typically step 4, 3 or 4 is arbitration. The grievance kind of transforms from being a individual grievance to being a union grievance. So the union becomes the enforcer of the contract and proceeds to arbitration on behalf of that individual. And so, although arbitration may resolve an individual's dispute, that individual is not the party, but rather the union is the party at arbitration.
Gotcha. Thank you very much for that. I think that clears it up. Finally, are there any legislative changes that you believe could enhance PERB's effectiveness?
I think PERB is very effective at its current state. We do foresee challenges that may arise, but we will definitely keep the committee informed with any potential legislative changes. But at this time, I think PERB is doing a very good job at resolving disputes that are presented to it.
All right. Well, you mentioned earlier that the let's see, got it here. The 101 new cases was a threefold over what you had last year. And that you're back to pre-COVID caseload. And with I'll say the noise from the federal world of labor, do you see this 101 going up during this FY year to maybe 150? Just trying to understand where you think the office is going. Clearly, it will be affected in one way or the other, but I'm just trying to get a handle on.
I think the the current environment in the district and for the past few years, the labor environment nationally has provided more information to individuals about labor rights. So, you look at like the Starbucks organizing or the Amazon organizing, and then you look at the challenges that federal employees are facing, and you oftentimes hear a refrain: go check in with your union, go work with your union, and so I think in that environment, as employees become more aware of their union rights, and in DC, well, in the district, we have such a concentrated number of employees that are unionized. So, I think it's natural that we will see more cases. The increasing caseload, I can't predict. It anticipate that it will at least be consistent with FY '23. The extent of which I'm not sure.
All right. As it relates to your public monthly meetings, what does the board cover during these meetings as it relates to your agenda? During these meetings, are decisions announced regarding various cases or just what?
At a typical board meeting, the board will review the minutes, provide a description of the cases that is on this agenda, and then enter a closed session for deliberations consistent with the Open Meetings Act. After the deliberations, they will reopen the meeting and then provide its decision on the cases that were on this agenda. And so we do announce decisions at our monthly meetings.
Okay.
Yes.
And finally, when should a union turn to PERB or file with Superior Court?
For most matters, PERB has jurisdiction prior to an appeal with the Superior Court. There's a narrow section of case law which would require a party to seek a stay of arbitration with the Superior Court. Outside of that, many issues statutorily, like unfair labor practices, negotiability appeals, those things, arbitration review requests, those things under the statute should begin at PERB.
All right, okay. No, I have another one. Final concern is, well, not concern, but question, as it relates to your rules and regulations, which you operate as an independent agency, what is the publication timeframe for any change in the rules?
Mhm.
Is it 45 days, 30 days, 2 weeks?
Consistent with the Administrative Procedure Act, we publish a notice of rulemaking. I think that's 30 days. And then it comes back to PERB for a publication of final rulemaking, which I believe is an additional 30 days. The board, the last revision of the rules, I believe, occurred in 2018. I may be off a year or two. But I think that rulemaking went through at least 2 rounds of a notice of initial rulemaking before they published before the board published its final rules. And we had a public hearing where we elicited the feedback of the labor relations community. And I think the board is considering draft rules. It's in the deliberation process now. It's been on our agenda, I think, since November. And so with the initial publication of rules and the initial notice, I think the board will stick to its practice of at least having one public meeting strictly on the rules to get feedback from the labor relations community.
And that meeting would be open to all of the union community members, not just the bosses, so to speak?
Yes, it will be open completely to the public. So
Okay,
if there's a labor scholar or a member of the public that believes, the rules could be more effective or have comments on the proposed changes, they're welcome to come to the meeting and make those comments
All right.
or submit comments in writing.
all right. And you'll let us know when you're doing that. Give us at least a week notice.
Of course.
Okay, so we can get the information out. All right. Well, thank you very much, Mr. Sims, for your chatting with us today. We appreciate it very much and look forward to talking with you more in about 6 weeks when we talk dollars and cents. as it relates.
Thank you. It was a pleasure. I always thank my staff for helping me prepare for today.
Excellent.
All right, thank you.
Very good. Thank you. And now we will hear from the Office of Employee Appeals. We're going to have some comments, some discussions with the, thank you, the Executive Director, Ms. Sheila Barfield, and her team. She has her team with her today. And as they assemble, we'll ask you to raise your right hand and we will swear you in. Do you swear and affirm that any testimony and any statements that you make before us today to be truthful and complete? Thank you. Thank you. And before you begin, I'll just quickly remind the public that the Office of Employee Appeals is an independent administrative adjudicatory agency, excuse me, that process appeals filed by the district government's workforce. Such appeals may be brought where an employee has been removed because of an adverse action for cause, placed on enforced leave, suspended for 10 days or more, subject to a reduction in force, or affected by a safety-sensitive designation. And the Office of Appeals, Employee Appeals, or OEA, consists of a 5-member board, an executive director, a general counsel, and an administrative support team, and 6 administrative judges. So we've heard a little bit this morning about PERB and OEA, and I think I heard OEA mentioned probably twice as frequently as PERB, and I think that's because individuals within our government, whether you're in or out of a unionized work station, can take your concerns to OEA. So, Ms. Barfield, thank you for being here with your team, and we'll take your testimony now.
Good afternoon, Chairperson Bonds and the Committee on Executive Administration and Labor. My name is Sheila Barfield, and I am the Executive Director of the Office of Employee Appeals. I'm joined today by my General Counsel, Lashika Brown-Bassey, Senior Administrative Judge Eric Robinson, and Chief Operating Officer Himchan Himraj. Thank you for this opportunity to testify before you and the committee regarding OEA's performance for fiscal year 2024 and fiscal year 2025 to date. As you know, OEA is an independent agency whose mission is to render impartial, legally sufficient, and timely decisions on appeals filed by district government employees. OEA offers district government employees and agencies a 3-part appeal process consisting of mediation, adjudication, and petitions for review. In addition to the 3-part appeal process, OEA also considers motions for compliance and motions for attorney fees. OEA has a 5-member board of directors. Currently serving on OEA's board of directors is Deanna Maria Lewis, chairperson, Arrington Dixon, board member, LaShawn Adams, board member, and Jean Moorhead, board member. And I was just notified earlier today that a 5th board member is set to join the board, Pia Winston. Thank you, committee and Councilmember Bonds, for pushing that through for us. We appreciate that. With respect to OEA's performance, the agency had a successful FY 2024. We issued 89 initial decisions and 16 opinions and orders on petitions for review. We significantly improved the efficiency of handling employee filings and agency responses with the introduction of the email filing option. Of the 91 petitions for appeal filed in FY 2024, 55% of those were received via email. Of the 82 agency answers filed, 33% of those were received via email. This initiative, which is a precursor to a fully electronic filing system, which we hope to get, if everything goes as we would like, at FY '26 has enhanced operational efficiency by speeding up documentation processing, reducing mail delays, and cutting postage costs. We look forward to the day when we have full electronic filing. We were also able to provide various continuing legal education opportunities for the administrative judges and general counsel's office. One of the courses we participated in dealt with AWOL employees and the unique situation of AWOL with respect to employees who telework. Another course provided training on judicial writing and evidence challenges for administrative judges. Additionally, in the first quarter of this fiscal year, 2 of our senior administrative judges and one of our paralegal specialists attended a training entitled Artificial Intelligence for All Judges and Lawyers, a comprehensive course. Because AI has become a reality, I believe it is important that we recognize the utility of and limitations on artificial intelligence in the legal system. Moreover, in quarter 4 of FY 2024, we began the recruitment process for hiring a paralegal specialist. The hiring process was completed in November 2024. This paralegal specialist provides support to the administrative judges. We now have only one more position that remains vacant, and the recruitment process for filling that vacant position, which is the senior administrative assistant position, will begin in the 3rd quarter of this fiscal year. I believe that fiscal year 2025 will be another successful year for OEA. In the 1st quarter of this fiscal year, we held our annual board member appreciation and recognition luncheon. During the luncheon, we thanked and bid farewell to 2 board members whose terms had expired, and we welcomed 2 of our newest board members, LaShawn Adams and Jean Moorhead. Thus far this fiscal year, we have issued 23 initial decisions, although I think it may be about 24 or 25 by now. Oh, actually 30. And 4 opinions and orders on petitions for review. We have conducted 7 evidentiary hearings and 1 board meeting, with the rest of the board meetings having been scheduled for the remainder of this fiscal year. We are in the early stages of creating a quarterly newsletter bulletin, which will inform the public about the work done by the agency and any cases issued by the courts impacting the agency, as well as any activities we may have participated in during that quarter. Lastly, we are in the process of identifying additional training opportunities that we may be able to participate in. The significant work which OEA performs provides a valuable service to the district government as well as to the citizens of this city. We all have an interest in knowing that employees with performance deficiencies are having those deficiencies addressed in a manner that is in accordance with the law. This concludes my testimony.
Thank you very, very much for that testimony. And I guess I should start with the presentation we heard earlier today from MPD FOP, their union. One of the concerns was that they talked about their old grievance process where they could jump to an independent arbitrator, which is seemingly the preferred approach. And now they must come to you effective November 2022. And they are saying, oh, it's taking so long to resolve. So can you speak to the consequences of adding MPD's disciplinary appeals into your agency's jurisdiction?
Well, with all due respect to that person who made that testimony, I believe that he's misinformed about how it works at OEA. So far, we have received 13 of those appeals since that whole process was implemented. 7 of those cases have been issued, and it took on average 114 business days to issue those decisions. And as you know, the law allows us 120 business days within which to issue those decisions. So we actually issued them well before the time frame that was set. The remaining 6, I guess that leaves us, we're on average working about, 140 7 business days, really, to issue those cases, which is only, 27 additional business days over the allotted time frame. And there are a lot of external factors that go into the extension of time for the length of time it takes to issue the cases. Parties all the time request additional time within which to file their documents, within which to hold proceedings. And those requests for extensions of time are granted because good cause has been shown for granting the extension. So we grant those extensions of time. But we do work diligently to issue the cases on our end to get them out and issue them and make legally sound decisions with respect to those cases.
One of the points that I think MPD was attempting, I'm sorry, FOP, I should say FOP, was making clear, and there are questions about whether or not the agency has sufficient funds to handle the volume of cases. And therefore, they're concerned that it's taking longer because an arbitrator was faster.
Well, of course, we always would like additional funding for the agency. We've made no secret about that in the past. But I understand, where things are right now, and we have the budget that we have, and we work within our budget. So with respect to not having enough resources to handle those cases, as I said, we've gotten 13 of those decisions. I believe that we have adequate staff to handle the decisions, to handle the cases that we have. I believe that we have a good court reporting budget. We had, if I can just look at some data from previous fiscal years. In FY 2023, our court reporting allotment that we put in that category was $35,000. We spent $33,000 on court reporting. In FY 24, we allotted $40,000 in that category. We spent $32,000. So far in FY 25, we've allotted $45,000 in that category, and we have spent $12,000 thus far, which is about 27% of that amount allotted. So we do have adequate resources to handle that. As I said, there are a lot of factors, external factors that are not within the control of OEA that factor into the length of time that it takes to render a decision in a particular case.
All right. Tell us a little bit about what your office learned about the AWOL employee and the unique situation with respect to telework.
Well, I think I participated in that training as well. And I think that one of the things that was new for me really was that even a telework employee, even if they telework every day, can still be charged with AWOL because there are certain things that an employee has to do every day, even if they're teleworking, that has to be made known to the agency. Perhaps there's meetings to attend and you don't attend a meeting, or trainings to attend and you don't attend a training, or responding to emails or getting return phone calls, and you don't get those within the time frame that's been set. all of that can factor into being charged with AWOL. So yes, a telework employee can in fact be charged with AWOL.
I just wanted to see if we could talk a little bit about this coming out of teleworking into the office again. The Mayor Bowser, I think, asked that the agencies convert back to in-office work a few months ago. And I was just curious if you received a preponderance of complaints because of that, or if your complaint level is pretty much the same quarter after quarter.
No, we haven't received any complaints with respect to that. I can only speak really with OEA. We have been back in the office since July of 2021, when the first return to work order was given by the mayor. And so we've been, you know, for that length of time, we've been back in the office. Of course, we still telework a day or two in the office for those, but not everybody actually teleworks because not every position allows for that. So we don't all telework in the office. There are people who come in every single day. But with respect to other government employees bringing complaints to OEA about that, no, we haven't received any of those kind of complaints.
All right, that's good. I remember last year there was a petition floating around, and especially with the second version of return to work instructions. So I was curious if you got.
No, we didn't get any
Okay.
of that.
All right, so it was just for fun, I
Yes.
guess. Yes. Okay. Thank you for that. Well, has the agency received any safety sensitive cases yet?
We still have not received
Wow.
any of those, any cases that I don't know if that means none have, you know, no, I don't know really what that means. I would just be speculating otherwise. But
Okay.
no, we have not received any cases with respect to that particular law having gone into effect.
As we think about the efficiency or room for improving the speed and efficiency of the appeals process, what measures have you put in place? I know you have the e-filing, and that's probably pretty exciting, and the e-response, so that's even more exciting. But is that sort of like where you've landed on how to improve efficiency?
Well,
And-
it's not so much e-filing because when we say e-filing, we mean electronic filing. What we have right now is not electronic filing. We have email filing. We have a dedicated email box that certain documents can be sent to the email box. And those are petitions for appeal, the agency answer, petitions for review, an answer to a petition for review. And then we also send out our initial decisions and opinions and orders via email if we have the employee's email address on record. And generally, even if we don't, we call them to see if we can get it and send it to them via email. So right now, that's how, excuse me, that's how we have improved efficiency via a dedicated email inbox. Now, if we had electronic filing, then everything we got would be done through an electronic filing system, which would, I think, just take us to a whole other level of efficiency. But, you know, we're working with what we have. But in other ways, there are other ways that we have also improved efficiency. Once the agency answer has been received by us, I generally assign the case within that, say we get the agency answer that morning, the case will have been assigned by that afternoon to an administrative judge. If not by that afternoon, then definitely by the next day. So that in and of itself is also an improvement as well with respect to efficiency.
So your average time frame for resolving or reaching a decision in a case in FY '24 was how many days?
I'll ask the general counsel to
All
speak to
right.
that, please.
Hi. It took an average of 197 business days to issue initial decisions. Thus far in fiscal year 2025, it has taken 180 business days. And I just want to note that both of those are tremendous improvements on fiscal year 2023, where it took 231 business days, and 2022, when it took us 236 business days. So we are making progress to hit the 120 business day statutory requirement.
All right, that sounds exciting. All right. Let's talk about the percent of appeals that are resolved before they enter mediation or any other alternative dispute resolution. What are your numbers showing us about that?
Let me see. Oh, the general counsel has that information
right.
as well.
So we don't have the specific number to the question that you are asking before mediation. I can tell you the percent of cases that have settled through mediation and through litigation. So in 2023, we had 8% of our overall caseload settle. In 2024, it was 11.2%. And thus far in fiscal year 2025, we are at 16.6%.
Oh, okay. So I'm going to read this, meaning that mediation does definitely have its place. It works. Does it save money and time?
Good afternoon.
Hi.
Senior Administrative Judge Eric Robinson. Yes, they're much easier to dispense with once the parties have come to an agreement, have settled their differences. So yes, it saves us a lot of time, saves me a lot of thought that has to go into a decision that has to come out on the merits versus we could just take a few pages and just let the public know that the parties have resolved their differences and have decided to move on. And it also saves us in terms of the parties don't then go and have it reviewed by a higher court. So it saves resources in that regard as well, either Superior Court and beyond.
All right, well, walk me through some of what was explained by the FOP. They mentioned that minor misconduct issues, how are those the ones that would go, that were referred to you, that go to mediation? Or do any of the cases that come, that are filed with you, go through, any and all of the cases can go through mediation?
Our current process is with the parties' acceptance, any case that comes before us can go through mediation. We handle adverse actions, RIFs, and the like, as noted in our enabling statute. With that, if both parties want to go through mediation, most of the judicial staff has been trained, has gone through 40-hour mediation training, so that we can assist the parties in coming to a resolution that, and I like to say this when I'm a mediator, that you can live with. Full satisfaction, they have to go through the adjudication process. With mediation, if you can take something and live with it, they can move forward and go on with the next steps of their career.
So I'm trying to understand this thing about why some feel that arbitration is better than going through the mediation process. Sounds like they're very similar. Am I right on that, or?
So from my understanding, the arbitration process is spelled out in each individual employee's collective bargaining agreement. So it will spell out the process where an arbitrator can be utilized in terms of trying to resolve the situation that has brought that arbitrator to the table. With mediation, the parties have to agree to the solution. They don't just, the arbitrator will assess the evidence. They actually almost step in our shoes and say, this is the evidence that's presented by the agency, by the employee through their union, and here's the decision, live with it. Whereas a mediation, the parties come together, they come to a mutually agreeable solution. They both agree to it, which is why there isn't usually any review of that decision as they move forward. They don't have to review it. They've accepted it, whatever it was, and they've moved on with the next steps of their career or managing the agency if you're looking at the other side of the
Right.
coin.
And I think PERB told us earlier that with the arbitration, you know, there may be a high, I know it was the labor relations, there may be a high, and there's a low, and the arbitrator can select either one, as opposed to having to try to crush it and bring it to the middle ground.
Right.
Okay.
I think an arbitrator can actually make a decision on.
Yes, they
on the
do.
case.
One way or the other.
Right.
That's right. And so I just want, we have a number of employees that are listening. I want people to understand how this works, the magic of the process
Right.
that is presented to our government, and how they can decide where they're going to take or where they're going to file, so to speak. That's important. Thank you very much for that. So what steps does the agency take to ensure that its decisions are enforced by government agencies?
Well, right now, according to our rules, an employee would have to notify the agency, meaning us, OEA, of whether or not the agency that they work with is in compliance with the decision that we issued, once the decision has become final. So that means it becomes final 30 days after the initial decision has been issued, and if no appeals have been taken, then the employee can let us know if the agency has or has not complied with that decision. And they do that by filing a motion. If they have not complied, they do that by filing a motion of compliance with the administrative judge that issued their decision. And then the administrative judge can call the parties in to determine whether or not to see what actually has been done, and then go forward from there to see if the agency has in fact complied, if they're in the process of complying, they're not going to comply, and see what needs to be done.
So what has been the frequency starting in 2023 with the number of the filings that have to come back to your
Compliance
agency?
issues?
Yes.
I think we'll have to probably get that back to you, the number
No.
of compliance,
I think you said
Case-
motion of compliance.
motions for compliance,
Okay,
yes.
4,
We'll have to
okay.
get that. You said starting in FY 2023?
Yes, and I think it would be important to know whether or not we are moving in the right direction, which is to make sure that we are complying.
Okay.
Is there anything else that your agency can do when you have the discovery that the agency is not complying with your order?
If it is determined that the agency has not complied, then the administrative judge certifies it to the general counsel's office from at that point. And then I'll ask the general counsel to speak to that.
So we will then issue a general counsel's order on compliance. If there is still non-compliance, then we alert the mayor's office.
And that's the MOC?
I'm not
It's
sure what
probably the
MOC
city
stands
administrator.
for.
It's the office of the city administrator
Okay, all right.
and the mayor's office of legal counsel as well.
Yeah, it's all in our circle.
Yes.
Okay,
Yes.
just trying to Okay, we haven't gone outside of that circle yet, okay. And so what's the expectation when the city administrator's office is informed? Do they have a whip? Do they have, you know?
Well, I think our expectation is that that higher level will then reach out to the agency to find out what's going on. Why, if no, especially since no appeals have been filed with respect to the case, then, what's happening? Why haven't they complied with
Yeah.
the order of the agent of OEA?
I'm sure the city administrator will enjoy talking with us near the end of this month about that matter.
Okay.
So thank you very much for
Mhm.
that.
Yes.
Are there any instances where a party is mandated to pay the other party's court fees if that goes that far, or attorney fees?
Yes, there are lots of times when the the winning party, the employee has won, and the decision is now final, and the administrative judge has ordered that the agency pay the employee's attorney fees. Yes.
The administrative judges, they are not a part of your office. They're outside, that you, sort of like your consultants?
No, the
No.
administrative judges are full-time employees of OEA.
All right. And how many are there?
Five full-time and
Mhm.
one part-time, WAE.
Okay. That's adequate, you think?
Well, as I've said, we are always looking for additional ways, additional resources for the agency. Right now, I believe we have what we need as far as people. But, in the future, we could probably, depending on how everything turns out, we could maybe use another administrative judge.
Let me just think about, for a minute, about what's going on in the marketplace now. And I think a lot about the fact that we are still a federal entity, and we have individuals that are paid through our federal, grants. If we will, I wonder sometimes if any of those employees would be affected with the, I guess I'll call it the layoffs that may happen at the federal level. And if so, I would imagine you'll get a number of concerns, filings. Am I correct?
Well, maybe if somebody is a DC government employee whose salary is paid through a grant that is a federal grant that is not
Yes.
renewed or whatever.
Yes.
And so they then have to perhaps have their position reduced in force, a reduction in force. It could be, I don't know for sure, but it could be that employee would be able to file an appeal with OEA.
Yeah, that's what I'm thinking about too. What might happen within our government, so.
Yes,
So you could very easily have a
could.
balloon of,
It could possibly,
Yeah.
yes. Possibly.
all right, okay. Just know I'm thinking about you.
Yes,
Okay,
I appreciate
thinking
that.
about you,
We
okay?
definitely appreciate
I'm not
that.
trying to have us to venture that this will be the case,
No,
but
we,
in this world, we
absolutely.
don't quite know
yes.
where all the parts are gonna land,
Absolutely, absolutely.
so. We've received complaints about internal employee investigations within agencies. Individuals have noted that these investigative bodies are often biased since they are embedded within the agency, and claims are often filed and found to be unsubstantiated. What issues and challenges have you noticed regarding the administration of agencies' internal investigations? Anything?
I don't think that we have had any kind of interaction with that. Now, I don't know, maybe within a case that an administrative judge handles, maybe that could come up as an issue, as something to consider. But maybe the 90-day rule might factor into that.
What is the 90-day rule?
I'll ask the administrative judge to speak to that, please.
90-day rule.
Oh, that was repealed? Oh, thank you.
All right.
I believe that was repealed, but basically that rule said that agencies had 90 days to bring an action against an employee. So they didn't have this cloud of, oh, you did something 2 years ago that we're now bringing up because we want to bring it up, something you did 2 years ago. You have 90 days from when you knew or should have known of an act that you react to it, basically. And that's what it said, but I believe it's been repealed. It started off with, I want to say the fire department and the MPD. And then there was a version that was put into the DPM that applied district-wide. And then it just went away.
Let me ask you, does your office receive notifications of all adverse actions against employees?
Well, we receive, if an employee files an appeal with OEA, now I believe agencies have some sort of internal appeal process that, I guess an employee can go through before coming to OEA. But we have, once the final decision has been made by the agency director, to uphold whatever discipline has been set down, then that employee can file an appeal with OEA. The final notice provides the appeal rights to OEA.
Okay. I'm thinking about the mayor's order that stipulates how we handle like sexual harassment as an example. That's the most recent one that we're familiar with. And it just seems to me, if there is adverse action against an employee, it would be useful to know the frequency of that occurrence within an agency. Because how else will we ever get to the possibility that there is some discrimination within an agency, or there's someone or something about the agency that doesn't work for our employees? Thinking about employee rights, thinking about management rights for that matter, and how do we really capture that information so we can make improvements?
Well, agencies are required, once they take the disciplinary action against the employee, they are required to give the employee notice of their appeal rights. And those those appeal rights allow the employee to file an appeal with OEA with respect to the disciplinary action, the adverse action that has occurred against them.
So you could be the repository of all of that information so that as we think about efficiency improvements throughout the government, You can be a resource for all that great stuff that the city administrator's office says that they do. You could.
Well, I don't know about all, I'm not gonna go quite that far because I don't know all of what the OCA does. But if an employee files, I know that an agency is required to give an employee notice of their appeal rights.
All right.
And so if that generally includes OEA, they can appeal.
And
to
a
OEA.
copy could simply come to your shop and you could be the repository.
If that's what the
Yes.
direction, yes, we could
All
possibly be
right.
that.
Just want to make sure that we're in agreement that that is a
Yes,
possibility.
that's a
Thank you
possibility, yes.
so much. I do have a question here about reduction in force, but given the conversation we've had, I think you kind of touched on it, but I'll ask, have there been challenges in determining reduction in force claims?
I'm going to defer to the administrative judge on that. I'm not aware of any particular challenges. I don't think that the government has done a like government-wide type reduction in force, like has been done. DCPS, like several years ago, did a extensive reduction in force. And all those cases came to OEA, but that has not occurred for a while. So I'm not aware of any particular challenges with respect to reductions in force. I know we don't get too many of those cases right now, of those appeals. So that's why I'm thinking there aren't too many reductions in force occurring within the government. But
I hear you, and I'm thinking about the $6 billion that's a part of our budget that are federal dollars. And so,
yeah, like I said,
just
I
the
mean,
thought.
yeah, I mean, that could be with all that's occurring right now, that's a possibility. So yes.
How does your agency ensure consistency in your rulings across similar cases? Is there like a sort of a benchmark or some principles you subscribe to and checklists for each case or?
Well, we talk all the time. We have regular staff meetings once a month within which the judges, we all talk about what cases are on each person's docket and determining what similarities exist between the cases and where it looks like the evidence and the law is taking us on those particular cases to ensure that we are issuing consistent rulings across all of the cases. That's how we generally do it. We just, I guess, the old-fashioned way. We come together and we talk about it.
All
I'd
right.
like to add that we also, the General Counsel's Office, we send a summary of all of the Superior Court and Court of Appeals decisions as we receive them. And we talk about those cases when we meet during our monthly staff meeting.
Yes.
All right, thank you. So how does your agency engage district employees? How do they know about the great opportunities you provide to them?
Well, I guess the way that they are supposed to be informed is by the final notice of the agency's action. When the agency gives the employee their final letter with respect to whatever disciplinary action has been taken against that employee, they should have a paragraph within that letter that says, you are entitled to appeal this decision to OEA. They give our address to them. I think our phone number, email address, letting them know, and the length of time within which they have to appeal. that decision to OEA. So that is how the employees are to be informed of what their next step is.
All right. Do you know whether your information is a standard, contact information is a standard part of the employee handbook or the information that employees receive when they sign on first day?
I doubt it because we're really come like at the tail end of somebody at a disciplinary stage. So I would hope that at the beginning, you're not looking at disciplinary action at that point when you're first hired. But if there's disciplinary action through your tenure or, in your tenure, then at that point, they are to be informed of OEA and their appeal rights at OEA.
Do you receive, does your agency receive complaints from employees that feel that they've been overlooked with a promotion, or that they were informed they were going to get a bonus, but the bonus never materialized? Those kinds of situations we've heard of.
Well, those are really considered grievances. Now, several years ago, we got all of those kind of complaints that are classified as grievances. But when the law changed, and I don't really remember the exact date when that law changed, that took grievances away from OEA, we no longer got those grievances presented in that manner. Now, what could happen is that in appeals that are filed with OEA regarding someone's adverse action that has been taken against them, the employee may just raise those issues as well. But we really don't consider them. We classify them as grievances. And so we don't, can't really render a decision on those right now. So no, we don't.
So what happens to a grievance?
I think
it
that-
just floats around?
Well, I think that the agency is supposed to handle it internally with respect to that issue for the employee. And I don't know the outcomes of those.
Okay,
But when we handle them, we would actually render a decision.
yes. All right.
And we're equipped to do that, so.
Yeah, I think we're now looking at least a dozen employees in your
Yes, I
agency.
mean, we would
You
welcome
have the
those.
space to accommodate them?
We would welcome those issues again, those appeals again, yes.
I think that they're very important. From what we have heard today, maybe things are minor, but they do not need to go through, a full-blown, hopefully take you to court ultimately situation that might be resolved through an administrative process.
Yes, yes.
Just seems to me if we have regulations that stipulate the opportunity for salary increases, we ought to follow that. If we have a process for awarding bonuses, we ought to follow that. And I will be pushing for that, just so you know.
Well, we are well equipped to handle all of those
Okay.
issues.
I think you made it clear that there may be some statutory changes that you would be
Yes, we would be in
interested
favor
in.
of.
Yes,
Yes, we would
thank
be in
you.
favor of.
Well, thank you very much
Thank
to your office, your team. We're ending very, very early, surprisingly, but you all are fantastic. So thank you very much for spending this time with us, talking a little bit about the Office of Employee Appeals. Is there anything else you'd like to put on the record?
Not at this time, except that we we appreciate this opportunity that we've had to speak to you today. And we look forward to the coming budget hearing. And we will
Great.
also get this information regarding motions for compliance. The number that we had in FY 23, 24, and 25 to date.
All right.
We'll get that back to you. And
right.
we certainly appreciate working with you and your staff.
You too. Thank you very much to your entire team. Thank you. I thank everyone who participated in today's performance oversight hearing for their contributions, of course. I think we learned a great deal, and I hope those who watched have a better understanding of the work of these agencies. As we move forward, we will seize this opportunity to build personnel, labor, and management relations. Since we are a united government with obligations to district residents and the public at large. If the public has any additional thoughts or would like to submit written testimony regarding the performance of these agencies, please upload it to the hearing management system at dccouncil.gov, or you may email it to seal@dccouncil.gov, and that is CEAL. The hearing record will close 10 business days from today on Wednesday, the 19th of February at 5 p.m. I would urge anyone interested in submitting written testimony before that date to please move forward with that to us. The next performance oversight hearing of the Committee on Executive Administration and Labor will be on Monday, February 10th, when we will be hearing from public witnesses that will testify on the Department of Employment Services. And this concludes our hearing today. With that, it is now 1:33 p.m. on the same day in which we started. That is February 5th, 2025, and the meeting is adjourned. And thank you to everyone again.